all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and its honorable court. Be seated, please. Case number 18-1051 et al., Mozilla Corporation petitioner versus Federal Communications Commission et al.
Good morning. Just before you start, I wanted to let everyone know that we're going to take a break between the petitioners and respondents' arguments because we have a long argument session ahead of us. Okay, let me start.
May it please the court, Pantelis Mikalopoulos for petitioners. First of all, I would like to express my appreciation for our colleagues in the FCC and in this court who had to prepare for this case in the difficult circumstances of the shutdown. Perhaps they can try to make up for it during the break. And I would like to reserve 5 minutes. This order is a stab in the heart of the Communications Act. It would literally write telecommunications out of the law. It would end the communications agency's oversight over the main communication service of our time. When I buy broadband access from AT&T and I pay $90 or $100 a month, and I order a movie from Netflix, AT&T will carry that movie for me. It will not add scenes. It will not subtract undesirable actors.
Well, the order, and in this respect, the order follows a succession of statements of the Commission going back to 1998, speaks of the combination of data transmission with computer processing, information processing, and so forth. And you actually, except with respect to DNS and caching, which we can come to, never really respond to that. But it's a theme in this whole succession of orders, the Stevens report, the cable broadband order, the the wired communications order, and the current order, with the gap being obviously 2015.
And so if you're referring in 1998, Your Honor, to the Stevens report, that had to deal with non-facilities-based internet service providers, and the court made clear that it was a much more complicated issue when it came to facilities-based internet service providers.
I agree.
Yeah,
Clear.
yeah. And then as far as DNS and caching, I will return to it, but the short answer to that is that they fall within the network management exception, and even if they did not, the FCC did not ask the right question about it. What we have when I order that movie from Netflix is a transmission of packets. AT&T will take me to Netflix. It will not take me to its own affiliate, DirecTV Now. It will transmit information of my choosing without change between points I have specified. That's the statutory definition of telecommunications. And so, in classifying this service as a telecommunication service or an information service, the FCC had to answer the question, is AT&T offering me telecommunications within the meaning of that definition? The FCC refused to answer that question. At paragraph 52, it says, I've already defined the companion term, information service, broadly. Information service is already defined as provided via telecom, and therefore that's it. We do not need to further address the scope of the telecommunications definition. And so you will hear a lot from the FCC about reasonableness and about deference, but there can be no reasonable interpretation if there is no interpretation in the first place. And you will hear a lot, and that goes to your question too, Judge Williams, about restoration of the past. But this order does not restore anything except an imaginary past. In 18 and a half out of the last 20 years, the FCC had in place rules or principles against misconduct by ISPs, sometimes outside Title II, sometimes within it. And the FCC tries to dress in the garb of Brand X. Here's what Brand X said.
Before you run into Brand X, can you just make clear for me, is it your position that telecommunication service and information service are not mutually exclusive, that you can be in both, you can have a foot in both camp?
No, that's not our position. Our position is that indeed information services and telecommunication services are mutually exclusive in the sense that the same service cannot be both.
Right, so then when the FCC, you complained that the FCC had not addressed telecommunication service, but once it finds that broadband is a information service, hasn't it necessarily found that it is not a telecommunication service? I'm just
No.
want to address that one argument that you made.
No, but because our position of mutual exclusivity does not preclude the other position, which is also ours, which is the same carrier can provide two services, one information service, one telecommunication service. And this has been established by the USDA court. When faced with the argument that this was an information service, it said, well, it has to be via telecom. So this takes us back to the question of is telecom
But
separately
it sounds like they're
offered.
not mutually exclusive. You can be doing some of both.
It could be that the same, and there's no doubt, I don't think that anybody contests that the same entity could provide the telecommunication service and an information service. It's just the same service cannot be both. That's our view on mutual exclusivity. So in Brand X, the court said telecommunications is a necessary component of broadband access. Telecommunications service is defined as the offering of telecommunications, and therefore the agency had to determine whether telecommunications is separately offered or whether it's functionally integrated with information services provided by the cable company. Now that those services have atrophied, the FCC comes up with a different rationale. It says,
I'm sorry, now that they have what?
Atrophied.
atrophied.
Oh, but you're assuming that Brand X rests on the walled garden relationships, right? Apparently. But Brand X is quite clear, for example, saying when an end user accesses a third party's website, the commission concluded, he is equally using the information service provided by the cable company as when he accesses its own website, et cetera.
Yes, Your Honor. This is, the FCC tries to muddy the waters by repeatedly citing this snippet from page 1999.
I would
the
say
mention,
that snippet is repeated in
Well-
one form or another in many ways.
well, I don't think it's repeated. The mention of access to third-party websites is only in connection with what you just next read, the information service provided by the cable company. It's the information service provided by the cable company that facilitates that access to third-party web content. And the court went on in that same paragraph to give two examples, DNS and caching. And let's look at the cable modem ruling, which was at issue, of course, in this case. Here's what it said, paragraph 38, in its words. As currently provisioned, the cable modem service includes email, news groups, maintenance of a user's web presence, this is web hosting, and DNS. That's all. And then the FCC continued, accordingly, we conclude that cable modem service is an information service. And Justice Scalia, in his dissent, but not while dissenting, while describing what the FCC had said, says this verbatim at 1006. Once connected, consumers often use capabilities and functions provided by third parties other than the cable company. Nevertheless, for purposes of classifying the service, the FCC, with this court's approval, has put all the emphasis on added applications and functions provided by the cable company in the same package. And so the FCC has come up with this different rationale that internet access is an information service because it is.
Just slow
internet
down
access.
momentarily. In the cable broadband order, there are frequent assertions that the service combines computer processing, information provision, computer net activity with data transport. So you're saying that that was the focus was exclusively on things within the walled garden?
Yeah, that's what the ruling said at paragraph 38, and look at paragraph 1 as well, where it talks about added applications and functions added by the cable company, and look at paragraph 11, which talks about cable modem service, usually including a browser as well. It's all within the walled garden, and Justice Scalia said that.
But I don't understand exactly where that gets you, because while the internet has changed a lot from 2004, there are some things that remain the same. I mean, Comcast is also part of NBC Universal. So it's a provider that also has its own content. So when people are using the Comcast broadband to access NBC Universal information, then it's an information service, but if they're browsing for something else, it's telecommunication service. I mean, how are we supposed to slice the bologna here?
Yes, there's no argument in the record by any side that the video capabilities of Comcast, let's say a Comcast video streaming website, is bundled with the transmission component of broadband access in a way that makes the two inextricably intertwined. That's not the argument that anybody makes, partly because those services partly are priced differently. So there is no argument that there is functional integration there. What Brand X was saying, is there functional integration from the consumer's perspective between the transmission component and the ISP provided information services? So the FCC jumps. It says internet access is internet access, an information service, because it is internet access. It accesses the internet and was designed to. The rationale is that an information service is the offering of a capability to provide one of 8 information processing functions, and broadband access is a conduit to that, to the millions and billions of information services found on the internet, and therefore it must offer that capability. But this argument was explicitly rejected in USTA. In USTA, the petitioner came to you and made that precise claim.
Just slow down a moment. Yeah. Throughout your brief, you refer to decisions of USTA as ruling that the statute requires such and such a thing. At every point, USTA very carefully said that the Commission's decision on this was reasonable. It did not say it was mandated by the statute.
Usually, Your Honor, that's correct, except in this case. And this is page 698 of the USTA case. That was not through the filter of evaluating what the agency said. That was a threshold argument that USTA had made under Chevron Step 1. And it had said in that argument, broadband access is an information service because it offers the capability to access each of the 8 information processing functions. This court had—
Which page are you reading from USTA? Which page did you say?
698.
I mean, the court did say that, but then the court also, in the next paragraph, went on to say we don't have to resolve this dispute or something along those lines.
No, what it said was we disagree because information service is also defined as provided via telecommunications. And this takes us back to the Brand X question of whether telecommunications were separately offered. So it was squarely and flatly rejected, and not through the prism of evaluating what the FCC had said. If the FCC were correct about its reading of Brand X, that it extends to information services beyond those provided by the ISP, USDA would have been decided wrongly. And of
I
course,
just read that page in USTA is describing the commission's position. It's not the court's analysis yet. It's just describing the commission's position, is it not?
no, I may
Everything on
have
that
the,
page is describing the parties' arguments.
so it's the threshold argument made by USDA. And the court says before we address what the FCC did, USDA itself makes a couple of threshold arguments. I thought, oh, I'm sorry, 703. I'm sorry, Judge. I apologize.
And where are we on 703? Oh, U.S. Telecom argues?
Yeah, I want to say, yeah, it's the first column, but
Yeah.
I don't have,
Well, I mean, essentially all the arguments made by U.S. Telecom on that issue were rejected. In fact, on every issue. But that doesn't mean that the opposite was mandated.
well, it means that the argument that USDA made and the facsimile of which the FCC made below was rejected.
Well, it just means neither one wins under Chevron Step 1. The fact that they don't win under Chevron Step 1 doesn't mean the opposite is mandated by Chevron Step 1.
Yeah,
It may mean that you're in Chevron Step 2 land. So I'm not, I guess I still don't understand.
Well,
Chevron
it certainly
Step
is
1.
wrong under Chevron Step 1, and there's absolutely no effort to, I mean, the court didn't even consider going further and discussing it under Chevron Step 2. This court has
We don't
rejected.
usually, I mean, Chevron Step 2 applies to agency decisions, not party positions.
Right, exactly, exactly. And so, but we have all of those quotes from the Brand X court itself, referencing information service provided by the cable company, from the Scalia dissent that describes the decision as putting all the emphasis on information service provided by the cable company. And we have the cable modem ruling that says at paragraph 38, that's why cable modem service is an information service. Email, news groups, maintenance of somebody's web presence, and DNS. And so this would shrink
Why was,
telecommunication-
what was the rationale for making DSL telecommunication service?
The rationale was the correct rationale, that it was the transmission of packets from one point specified by the user to another without change. And so we believe that's the correct rationale, and that's why we're saying that in most of the last 20 years, whether under Title II, as in '98, or subsequently outside it, there were rules and principles guarding against misconduct. So the FCC says, no, it would not shrink telecommunications to nothing because the telephone network is not designed to access third-party information services. But when I call my airline and I'm told, press 1 to talk to a consumer service representative, I do press 1, and the network is configured to allow the airline to process my command. Nothing occasional about that. But this doesn't make AT&T into an airline. Imagine the Surface Transportation Board, this agency's sister agency, looking at a train and saying, this train is not a train. It does not provide transportation subject to the Interstate Commerce Act. We don't need to regulate it because it carries coal to a power plant which processes it to electricity, and because the rail cars were configured to not let the coal fall off. So this is what happened below. The FCC is looking at the transmission between points specified by the user without change of the user's choosing, and they're saying, I don't need to decide whether that transmission is an offering of
I just need to be clear. Are you arguing Chevron Step 1, plain statutory language, requires categorization as a telecommunications service?
No.
Or no, you're arguing simply that their reliance on capability violates Chevron Step 2 analysis?
No, the reliance on capability does violate Step 1. As a general matter,
Okay, but if
what
it
is
has to violate
ambiguous?
Step 2 for you
So
to win,
what-
does it not?
So what is ambiguous and what properly belongs to Chevron Step 2 is the interpretation of offering as used in offering of telecommunications, in the definition of telecommunication service. That's legitimately ambiguous. Any argument that this is Chevron Step 1 is foreclosed by Brand X. But what is not ambiguous and what in our view belongs to Chevron Step 1 is the idea that a transmission defined as telecommunications is nonetheless not telecommunications because it falls within this extraordinarily broad reading of the information service definition. That's our Chevron Step 1 argument.
It's extraordinarily broad, but isn't that in part because the section has all this language about the various different capabilities, plus via telecommunications. So the fact that it comes via telecommunications does not strip it of its information service quality.
I do believe offering of a capability could conceivably lend themselves to a broad interpretation, but via telecom is actually a restrictive, not an expansive factor in the definition, because it shows that Congress meant information service to be something more than telecommunications, since it's via telecommunications. So if telecommunications is always a conduit leading to information services, so it has to be something more. So I think via telecom is a restraint. And so this is like a surrealist painting, which shows a pipe and captions it, "This is not a pipe." The backup argument is, as you foreshadowed, Judge Williams, DNS and caching. The FCC argues that DNS and caching are information services, and they draw into their orbit the transmission component, converting the whole into an information service. But this is like asking the sun to rotate around the Earth and the moon. One could deduce what the Supreme Court would have thought if DNS and caching were the only information functions provided by cable companies from those words of Brand X. It is no misuse of language to say that cable companies do not offer DNS. And so this court upheld the FCC in the USDA case and upheld the FCC through the prism of the evaluation you described as holding that DNS and caching fall within the telecom management exception. For a simple reason, they facilitate.
To be exact, it deferred to the
Yes.
Commission's finding to that effect.
That is correct. For a simple reason, that they facilitate the underlying transmission. Now the FCC says no, because to qualify under the exception, a service cannot ever be of benefit to the user. That's what it says in paragraph 38. But the problem is,
More broadly, drew a distinction between managing the telecom facilities and serving users. Now,
Yes.
my own immediate reaction to that is everything that's done for the management of the network is for the purpose of getting customers and holding them. By the same token, pretty much everything that makes customers happy depends on something done in managing the network. But that distinction, obscure as it may seem and fuzzy as it may seem, was good enough for Judge Green in 1989, and I'm not sure why it shouldn't be good enough for us.
it was not good enough for Judge Green, Your Honor. The FCC cites a two-page unpublished opinion by Judge Green from 1989, you're right, for the proposition that the exception is directed at internal operations. That's what the FCC is citing. The problem is that in this two-page unpublished opinion, Judge Green takes back the proposition in the footnote. Footnote 7 says, but of course, we have held that the exception covers the provision of directory assistance by Baby Bells to their customers. And then they say, well, all that we're saying is that the exception doesn't apply to communications between two users, because what was at issue in this case was relay services. And so none of the authorities cited by the FCC, I draw your attention to note 135, supports its proposition. All of the services listed as falling within the exception in that footnote are services that benefit the users, whether it be directory assistance or call forwarding or speed dialing or switching techniques. And as for the other Harold Green cases, the 87 and 88 Western Electric cases, they are the height of obscurity, but one thing they do not do is they do not hold whether or not the functions at issue there, address translation, storage, and retrieval, fall within the telecom management exception. And as for caching, the carriers themselves describe it as network management in their literature, as Jordan and
Can I just back up here again? Are you now making an argument that the statutory text compels that treatment of DNS and caching? Or are you saying that it's unreasonable under Chevron Step 2 for them at this time to treat DNS and caching?
This is primarily a Step 2 inquiry. I'm not saying that the statutory test mandates it, with one qualification, because there is also the issue that the FCC is bound by its previous rules. And if you look at the non-accounting safeguards order,
So look at what?
non-accounting safeguards order from 1996, paragraph 107 of that order says specifically, every adjunct to basic service qualifies under the telecom management exception. The FCC did not get to grips with that rule. It cited it, but it didn't abandon it and is still bound by it, and the order is inconsistent with it. But even assuming that the exception does not apply.
I'm sorry, it's bound by it because what? I mean, that's an interpretation of the language, and it's bound to that interpretation because?
Agencies must follow their own rules, service v. dollars.
They can change their interpretations of their rules.
Yes, but it didn't say change it and say it changes it. It changed it sub silentio. By the same token that in Comcast, the FCC had changed sub silentio the interpretation of Section 706. But even if they were information services and not subject to the exception, the FCC asked the wrong question. The question under Brand X is, from the consumer's perspective, is transmission inextricably intertwined with DNS and caching, with those functions? Instead, the FCC asked whether it is inextricably intertwined with other people's services. Here's what the FCC says at paragraph 46, verbatim. Consumers value the capabilities provided by ISPs to acquire information online. And consumers value transmission as a means, not as an end in and of itself. Everybody knows that. By the same token that the telephone.
Text talked about how the consumer understood what was being offered. How is that analysis supposed to be applied? Are we supposed to poll consumers? Is it a reasonable consumer? Not quite sure how we're supposed to, or do we let the FCC have a lot of room in telling us how consumers understand?
Yes, I'll give you an example of how it should have been applied. The National Hispanic Media Organization submitted a plain language analysis of 50,000 complaints filed by consumers. That analysis concluded, and it's uncontested in the record, that what emerged from the analysis of those 50,000 complaints was clearly a perception on the part of the consumers that, that the transmission component is not inextricably
When you
intertwined.
talk about polls, the first question is, what was the question? And nothing that we've been told from that point of view tells us what issue was put before these consumers. It's hard for me to believe that without that detail, this could swamp the rest of the record.
Yeah, and the detail is provided in the declaration, Your Honor, and establishes that customers view transmission principally as the means to getting to third-party service on the internet. So that's the reverse of what USTA said. In USTA, the court upheld the FCC for classifying the service as a telecommunication service precisely for the same reason that as the
I'm
court
not
put
sure I understood your answer to Judge Williams's question. Is it in the record what the interrogatory was?
Yes.
And what was the interrogatory?
Yes, well, I can try to replicate it, and I can come back to you at rebuttal, but they ask questions about whether customers viewed transmission as bare or as useful for leading to third-party websites. And I can get you more detail on that.
How many people in this country use broadband?
I think at least 80% is, I think, the statistic that.
So what is that? Millions and millions?
Yeah,
10
80%
millions?
would be many,
Millions?
tens of millions, yeah.
And so we know what the consumer understands based on 50,000 complaints?
Well, that's,
I'm really not sure what
Yeah,
we're
of
supposed to
course.
do with this language
course, and
that's in
perhaps
Brand
there are-
X. And your argument is, however consumers looked at it then, they look at it
Yeah.
differently now. And without understanding the lens through which you propose the law,
Yeah.
Brand X requires me to ask that question. I'm having trouble understanding how to answer, how a court could answer it differently. This court could answer it differently
Yes.
than the
Well,
Supreme Court already did.
You're right that there could be even better methods of doing it, but looking at the 50,000 people who actually have complained about broadband access is a fairly representative subsection. And in any event, it's much better than what the FCC did, which was nothing. The FCC did not look at one statement declaration by one consumer on what he
I
or
don't
she
think that's
perceives.
technically true, but in fact, the Supreme Court in Brand X did not look at anything or refer to anything looked at by the Commission in terms of consumer perception.
Well, but I think,
There was nothing in the record on it, but it reached
Yeah, I'm
its
not sure there was-
decision confidently.
yeah, I'm not sure there was
despite
nothing.
that gap.
I'm not sure there was nothing in the record, but I think there was more than what there was here, which was just the
Cited in Brand X
Pardon?
is evidence in the Commission record relating to consumer perception cited in Brand X.
Not in Brand X, and I'm not sure whether it's cited in the cable modem ruling.
So that raises a serious question whether Brand X filed a strong commitment to consumer perception as the device for resolving these issues.
Yeah, well, at least it purported to. But the FCC here, unlike in the cable modem ruling, takes the regulated party's word for it and then says, in any event, I think at paragraph 49 or so, we don't care. Whatever the consumer perceives, as a matter of fact, it's inextricably intertwined. And that was a mistake.
Assuming your characterization of that is accurate, is that a fault? I mean, it can't have, whatever Brand X meant in the allusion to consumer perception, it cannot have meant that a completely ill-informed consumer who has a perception controls, even if there are millions of them, controls this classification issue.
Well, I don't know about a million. I think you're right about one. But no matter what was wrong in paragraph 49 is to say we don't care what any consumer thinks. And in any event, here we're talking.
Is that incorrect if essentially a reasonable consumer or a reasonable understanding of what is being offered, that's how it came up in Brand X, then would it be fair to say, we're not going to poll individuals on this, here's what's going on? Is that, or is that?
Perhaps.
Is that acceptable or unacceptable under Brand X in your view?
Perhaps, I don't know. But what is not acceptable is for the FCC to say at paragraph 53, always necessarily the transmission component, because it says via telecom in the definition, is, as the FCC puts it in paragraph 53 or 52, intrinsically intertwined. That's not the test. It has to be a factual test. The idea of a functionally integrated service provided between Comcast on the one hand and Mozilla on the other, or between AT&T and Etsy, is a chimera. It exists only in the order. And so to return to Justice Scalia's pizzeria analogy, back in the world of brand X, the ISPs were in the business of baking pizza, and they were also delivering it. In our world, and in the record of this...
The majority did not accept Justice Scalia's pizza analogy.
Correct,
So
correct. But please
have to
humor
look
me.
at it in that.
Humor me for a moment. So in our world, the ISPs have essentially given up, mostly given up the baking, given up their ovens. And their service is now more akin to Uber Eats. It transports food made by others in other people's restaurants.
Actually, before I saw that line in your brief, I thought of another analogy, and it was pizza that came to my mind, because Justice Scalia's driving role in this, and it was Antonio's Pizza, which is a service that you can reach either by phone or the web, and it reaches a whole slew of pizzerias in the area, and you communicate with it, and you order pizza. Now, can that properly be described as a pizza service? And if not, why not?
Yeah, it depends on the particulars. It could be that it is both the baking of pizza and the delivery, if there's some affiliation between the two legs. But in the Uber Eats paradigm, the car transports, the restaurant makes, and there may be a refrigerator, a tiny refrigerator in the car to keep some of the food cold for the consumer, but that doesn't make Uber Eats into a chef. And it does not make it any less of a car that's obliged to follow the rules of the road.
But what do we do with AT&T, who's merged with Time Warner, and Comcast, who's merged with NBC Universal, and others of these providers that are also affiliated with edge providers? So are we supposed to say that broadband means one thing, and depending upon what kind of provider it is that's providing the service?
No, absolutely not, Your Honor. It goes back to our previous conversation. These types of services, so AT&T bought Time Warner, which means the Time Warner programming, and it has bought DirecTV, more programming distribution. There's no argument in the record that any of those services is bundled with the transmission component of broadband in a way that makes the whole into an information service. That's not in this case, because there are so many differences. The only issues are information services provided as a package with the transmission component, and this used to be email, news groups, a web page, and DNS, and whether, as the FCC argues, we should look more broadly and try to find a chimera, a functionally integrated service between Charter and Mozilla. But this goes to competition. And I would like, if possible, to skip my Section 706 arguments in the interest of time and go to competition. So if the reclassification were correct, despite our arguments, the FCC didn't do anything. It said, we acknowledge that blocking and throttling are serious problems, but it did nothing. Why? The first question was, the first answer it gave was, our hands are tied. And in this, it was more royal than the king, because many ISPs had said, well, you can impose rules outside Title II, and Comcast had said 706 is a good roadmap for such rules. The FCC ignored that, ignored the construction of 706 as an affirmative
Again,
grant.
counsel, you turn a decision of this court deferring to a position of the commission, in this case relating to 706, you turned that into a ruling that 706 meant that. And
No.
That's expressly rejected in Verizon.
I didn't mean to do that. What I was referring...
Sounded that way.
I thought I said the FCC's construction of Section 706 as an affirmative grant of authority was upheld twice by this court, in Verizon and in USTA. And now the FCC tries to take it back and demote it to an exhortation. And I said, I'm not going to discuss this, but here I am. When Congress says, thou shalt, it means you must. It doesn't mean it's a good idea. And the FCC says, well, there already was...
That's what Judge Tatel said was fine in Horizon. He said that would have been a reasonable reading.
Well, he upheld...
I mean, I know it's, in a sense, it's dictum, but...
Yeah. Yeah, I take that point, but look at the FCC's reasoning, which was not anticipated by Judge Tatel. The FCC reasoned that, look, a command would have been surplusage. Why? Because the measures identified in Section 706, we had already authority to take. But what's redundant about Congress saying, remember those measures that I had authorized you to take? Now I'm commanding you to take them to achieve a certain objective. And one of those measures, regulating methods to remove barriers to deployment, had never been authorized before. So to switch to competition, the next question, the next answer given by the FCC is we can trust the ISPs to do the right thing, to preserve internet openness.
That was, in a sense, an answer, but it was a part of a much broader answer.
Yeah, and so, but in paragraph 117, that's what they say, and they do reason. They said
the ISPs had incentives
yes.
Not to engage in this conduct.
Yes, and I was getting to that.
They acknowledged explicitly their circumstances where they have incentives to engage in the conduct.
Yeah. Well, I'm not sure about the extent of the latter, but certainly what they said was that many of the edge services complement the service provided by the broadband access provider, so why hurt them? And so in the best of circumstances, it's questionable for an agency to rely on the regulated entity's word for it, as this court...
It's not wrong to rely on perfectly standard economic analysis.
No, it's not, except the trust was misplaced because of the exceptionally flawed economic analysis. To borrow a word...
It goes on to identify the existence of other special circumstances where an ISP would have an incentive to misbehave.
Right, but it ignored the crucial evidence on that. So to borrow a phrase from you, Judge Williams, a reclassification without a market power analysis is like performing Hamlet without the prince. The true Hamlet has been absent from this stage. And it's not like...
Well, of course, that's a great tradition.
Yes.
Right.
And so if the FCC, it's not as if the FCC says the glass of competition is half full and we say it's half empty. It essentially acknowledges it's almost completely empty and says, so what? Witness page 87 of the FCC's brief, which says that 50% of the nation's households do not have a choice of high-speed provider.
Oh, now, high speed, this gets us into the whole question of 25 down, 3 up, and lesser speeds. And the charts included in the order indicate that when you when you have a less demanding standard, which apparently a lot of customers are content with and choose it in preference to high speed, you get, I think it's 79% with access to 2 providers.
Judge Williams,
Counting mobile.
yeah, I will draw your attention to footnote 454 of the order, which says specifically we don't take a position on whether lower speed providers are in the same market as high speed providers. They have not defined the market in that way.
Granted.
So 50% of the of the nation's households do not have a choice of high-speed broadband provider. And then as to other services, the FCC acknowledges there are serious...
Slow down on the high speed. There's very substantial data that customers presented with a choice between pricey high speed and less pricey low speed will take the low speed.
Right,
And I'm
that
gonna-
may be, but this analysis was not
Before you
conducted.
do that, could you just tell me the footnote number again?
454.
Yeah, I don't think that's it.
Am I wrong again? 454 says we don't.
Sorry, or my eyes are wrong, but I hope someone will tell me, because all I see at 454 is a C infra citation.
Okay, I'll find it.
You don't even have to do it right now. You can
Yeah,
do
I'll
it on
supply it
rebuttal.
to
I
you.
just wanted to
Yeah.
make sure you had a
Yeah.
chance to
Yeah, it says
point
we
me to
don't,
it.
we don't take a position on that issue. And as for other services, fixed wireless broadband and satellite broadband, they say there are serious questions as to whether they're effective
I take
competitors.
it your point is that if people only have one provider, we don't even know if they would choose a lower speed provider because they don't have any choice.
Well, yeah, in 50% of the households, they cannot go anywhere else. Now, even.
Your
and- and-
50%, that's entirely on the 25 down,
On the
3 up,
25, correct,
which you
correct.
insist, but
Correct.
contrary to the views of many consumers, I mean, a few million.
But again, no finding has been made by the commission. And I
Well,
think
it has the chart, I'm sorry.
it would attract the same criticism that you reserved for the USDA court in your analysis as to lack of a complete market power and market definition analysis. So as for mobile broadband, they acknowledged in another decision, broadband declaratory ruling, that it's not a full substitute. And all they say is that 20% of homes subscribe only to mobile broadband. But this means that for the remaining 80%, mobile broadband is a complement to wireline broadband, not a substitute. But perhaps most
It can be
important,
both, right? It's a substitute at some levels and a complement at others.
yes,
They're not
but,
mutually exclusive categories.
but again, the FCC itself acknowledging there are different services, different capabilities, and not full substitutes. And perhaps most important, the FCC has ignored evidence, this goes to your question, Judge Williams, that the providers have the incentive to hurt edge providers, as well as the ability to do this with impunity. And I will agree with you, there was some lip service given to the fact, as both the Verizon and the USDA courts have acknowledged, that those are the cable companies and the telephone companies. They face competition from online video and from voice over internet. So there is an incentive to hurt the competitor.
Right,
But-
I think you've gone almost double your allotted time for
I
argument.
can I take 1 minute?
You can, how about one sentence, and then we'll hear, and we'll give you some time for rebuttal, but one sentence, and then we'll hear from your colleague.
Okay, so there's ample evidence in the record that and I'll try to punctuate with commas, that
Just don't inhale.
that they can get away with impunity because subscribers do not leave when they do a bad thing, when they do block, throttle, and degrade, such as when Time Warner throttled Netflix and nobody left, such as when Comcast throttled Netflix and nobody left, such as the investigation of the New York Attorney General that uncovered systematic degradation of service in order to extract payments while the ISPs were continuing to reap a king's ransom and 97% profit margins.
Okay, that was a
which
nice long
means-
sentence, thank you.
Which means, just to finish the thought.
Thank you,
that-
thank you,
All right.
really. We have to move on. We have a lot of other people that want to argue. Thanks.
Thank you.
I think you just throttled him down.
May it please the court, Kevin Russell on behalf of petitioners. I'm going to discuss the APA and the Section 257 and the mobile arguments. Even if this court concluded that under Chevron the commission had a choice of classification, the APA requires that it exercise that choice through an exercise of reasoned decision-making. And for the reasons we've set forth in our brief, that order fails that standard in multiple respects. I'd like to start with the agency's principal justification, not only for its classification for decision, but for abandoning any role in enforcing good behavior among the ISPs by eliminating all the conduct rules. And that principal rationale was that it wasn't necessary, that a combination of competition, antitrust and consumer protection laws, and disclosure would do the job. My colleague was just talking about competition. I'd like to start with antitrust and consumer protection laws.
Can I just ask a doctrinal question?
Sure.
The respondent's brief says, look, once we do our legal analysis and conclude that this is an information service, we don't have the authority, the legal authority, to regulate in the fashion that would be akin to common carrier regulations. Verizon held that. And so we really don't need to have any other justification. I just want to get specifically your response to that.
Sure. So there is a sense that the first part of the order is the commission pretending to be a junior varsity Article III court, applying ordinary principles of statutory construction that courts apply and are expert at. And in the second part of its order saying, okay, here are our policy rationales. If that's what it's doing, it's not entitled to Chevron deference with respect to its legal analysis, because we don't defer to agencies because we think they are better than courts at applying ordinary legal analysis. We give them Chevron deference because we expect them to choose between reasonable interpretations of ambiguous statutes based on their policy expertise. And if they don't bring that to bear, they're not entitled to Chevron deference. I will say, I don't read the order as doing that. I read the order as justifying its choice in substantial part on its policy analysis, on these reasons that I was just trying to get to.
Which is what Brand X exhorted the commission to do.
That's right, but they have to do it reasonably, right? They have to do it within the confines of the APA. And so my first argument here is that they've failed that because they have pointed to antitrust and consumer protection laws as a backstop without engaging in any reasoned analysis about whether they actually can perform that function. To reasonably determine whether they can perform that function, the commission had to do two things. First, it had to identify the conduct that it believes somebody needs to prohibit in order to fulfill the purposes of the statute. And then it has to ask, well, do these statutes actually prohibit that conduct? Here, the order doesn't do either. We never get a straight answer from the commission whether it thinks blocking and throttling must always be prohibited, whether it's only a problem if it's done by a competitor against its competitor, if it's only a problem if it's done against a competitor when the ISP has market power.
Yeah.
We don't get an answer to that.
Its thought pretty obviously was that where it violates pro-competition policies administered by the FTC and I guess the Justice Department as well, and it can and should be stopped.
Well, with respect, I don't think that's a reasoned analysis. They can't simply say, we don't actually know what competition law prohibits, but we're confident that whatever that is, that's good enough for this statute.
You aren't really asking them to write a treatise on competition law.
No, but I'm asking them, for example, in paragraph 145, they make the assertion that the examples of bad behavior identified in the last order, in the 2015 order, could have been, quote, investigated as antitrust violations. It's not too much for them to ask for them to actually figure out whether those would have been antitrust violations. If they're saying, don't worry about this, look at these principal examples, all they're willing to say is that it could have been investigated. So, for example, they point to the instance when Madison River was blocking its VoIP competitor. And they say antitrust law, they suggest antitrust law, that's the solution. And they point to Section 2. But they don't ever recognize that Section 2 of the Sherman Act only is ever going to subject it to any scrutiny if Madison River had monopoly power or has had a dangerous probability of acquiring it. And of course, that's quite a showing, right? There's a difference between market power and monopoly power. Usually to have a viable Section 2 case, you have to show that the ISP has at least 50% market share. And so maybe the commission thinks that it's only a problem if blocking occurs with somebody with 50% market share but not 30% market share. We don't know. To the extent that they think that 30% market share of somebody blocking with 30% market share, they fail to analyze whether the antitrust law will do anything to remedy that. And it probably won't, for the reason that I just said with respect to Section 2. And with respect to Section 1, one of the reasons, for example, in merger proceedings, we ask not only will the combination result in monopoly power, but also significant concentration, is because we recognize that in a concentrated market that doesn't reach the level of monopoly power, a small number of competitors can coordinate their behavior without violating Section 1, without having an agreement that would violate Section 1 of the Sherman Act through phenomenons like price leading. But of course, that can happen with policies too. Verizon, for example, in a concentrated market, could float the idea of having a paid prioritization plan, knowing that if it loses market share as a result, it can just take it back, but also knowing that its competitors know this as well. And as a consequence, they will know that if they follow suit, if they all have paid prioritization plans, they'll all make a bunch of money.
The question is, why should tacit coordination be treated with special severity in this area as opposed to the market as a whole?
Well, to be clear, my point isn't to say that they were compelled to reach a particular conclusion about this. My point is they were compelled to conduct an analysis, and they just didn't. They nowhere acknowledge the problem of tacit collusion. They nowhere say that tacit collusion is fine, and they repeatedly say that, or imply that antitrust law will stop this behavior. They don't say. They could have written an order that says, look, we don't actually think antitrust is going to stop that. That's okay. That's okay with us. Had they said that, they would have to take political responsibility for that, and people could go to Congress and say, look, the Commission is relying on unfettered markets, and that's a problem. Pass a CRA, vote the administration out of office. But when they undertake to tell people who are skeptical about the ability of competition to control these problems that, look, don't worry, we've got a backstop. We've got antitrust law. We have consumer protection law. They have an obligation under the APA to conduct a reasoned analysis of whether those claims are in fact true.
It seems like where they give the most analysis is with respect to disclosure and the transparency rule. They say that, well, to the extent that a representation is made in a disclosure and then action is taken which is inconsistent with that representation, then of course there would be some sort of an action that would lie for violating, or I guess for deceptive practice, for, you know, representing that you're going to do one thing and then actually doing something else.
So
it does seem to be, at least that's one example where they are somewhat specific in saying this is an instance where we will take action, or where the FTC, we're confident, will take action.
Right. That stands, a couple points about that. That stands in stark contrast to their analysis of antitrust law, which they also point to as an independent backup. Number two, in the situation that I just described, we have a concentrated market where there is price leading or policy leading. There's no reason why the competitors can't all just impose, for example, a paid prioritization policy and then fully disclose it. There's no competitive consequence to it because there's not enough competition to exact any costs, because the consumers, if they don't like it, they don't have anywhere to go. And if that's true, if they just simply disclose their paid prioritization program or their throttling program, they're not going to face any potential liability under Section 5.
That does seem to be a potential issue. And of course, we all read those disclosures that we get on the internet.
Sure.
Very carefully.
Sure, and I take the point. In addition, it doesn't address the very real problem of blocking of offensive or unpopular content. If, for example, a provider decides we're going to block the Daily Caller, we are going to block streaming of graphic videos of animal abuse by an animal rights organization, they will be doing that precisely because they think that their customer base at large finds this stuff offensive. And there's no reason to think that competitive pressures, even when disclosed, are going to provide a remedy to that. Now, maybe it's the Commission's position.
Advantages of the net was that on the whole, people could choose where to go. So that people wanting to see these videos posted by animal rights groups can go there, and the people who are repelled by it can go away.
Well, maybe that's the Commission.
So I'm suggesting that therefore there's probably no profit percentage for the ISP to start banning them.
Well, so here's the point, though. I mean, the Commission's only explanation, only inquiry into this is in the paragraph 153, where they acknowledge, for example, that antitrust law is not designed to protect free speech values. And what they say is that market competition with antitrust law preserves the market competition that antitrust law preserves will protect values such as free speech to the extent that consumers value free expression. They acknowledge that in circumstances where consumers aren't going to leave their ISP en masse just because some speech they personally find offensive has been blocked, competition in antitrust law isn't going to deal with that problem. Now, it may be that their position is, we don't care. That's fine by us if a third of the folks in a particular area can't have access to a particular website because they can go somewhere else. The Commission hasn't said that, and it would be difficult to square with its obligations under the Act, and it would be difficult for them to defend that publicly. So again, I'm not saying that they can't have answers to this. I'm saying they don't have answers to this. They haven't adequately analyzed the problem or given a reasoned explanation for their.
Can I back you up on your the antitrust argument? What I'm trying to understand is, at this step in review, if they were, what would a court have to do to decide that their explanation about antitrust law is insufficient? Is it just enough, because they talk about it, it's not as though they don't address the issue. They do address it. That's why you're talking about it. If it turned out they were right as to antitrust law, would it be a problem because they just didn't spell it out in more detail? Or do you need to show, or would a court need to find that, in fact, antitrust law wouldn't be of much help here to find that their reasoning was insufficient because they were relying on something that, in fact, was too thin a reed to
It's an APA problem for an agency to give an inadequate explanation even when it's right. And here,
I'm sorry.
It's an APA problem for an agency not to give an adequate explanation even when it's right. And here, there's no reason to suspect
The adequacy here seems to turn on their correctness about whether this is a backstop. This isn't your ordinary situation. They're relying on a legal regime, and in their view, they seem to be figuring it will do whatever is needed to done to ensure adequate level of competition here. The misbehavior doesn't affect competition levels. And I'm just trying to figure out how to know when they've said enough without doing, as you've said, something that's not in their wheelhouse, and that is a treatise on antitrust law.
Well, to start, this is an easy case because you can't even evaluate any claim that they make that antitrust and consumer protection law adequately prevented tobacco because they haven't told you what it needs to prevent in order to function, in order to perform that function. And it's not
Similar to the 2015 order, which had the Internet Conduct Standard, which was a massive vagueness.
Well, I understand that was a controversial position. I do think it was
Not so vague as to violate the First Amendment.
No, we didn't think so. But regardless of what you thought about that old rule, the APA still requires them to justify repealing it and stepping away from decades of the FCC's commitment to be a cop on the beat to ensure that the principles of open Internet are adequately complied with, and that the harms that they recognize that can come through violations of Internet openness don't arise. Let me turn quickly, because I don't want to take too much time here, to the other pillar of their argument about why no FCC
Sorry, I
regulation.
just want, before you move on, I'll
Sure.
give you time to move on. But as to your second point about they don't sort of, in your view, they don't grapple with the consequences of providers just shutting down access to certain edge providers, certain information. Is it your view that they just have to say this could happen and too bad, so sad? Or is it your view that unless they had protections in place to prevent that from happening, or some guarantee that people would still have access to that information, that the choices that they have and providers are sufficient to ensure they can always get unfettered access to information, the rule's insufficient? I just want you to elaborate a little bit more on the nature of that problem.
So just to be clear, our APA challenge here is to the inadequacy of the analysis. We are not saying that something in the law or the facts compel them to reach a particular conclusion with respect to that. And again, it's important.
The adequacy of the analysis, in part, not in whole, but in part, depend upon the array of threats which is shown to exist and their plausibility and so forth.
Sure, it'd be one thing if the commission had written an order that said, we don't actually think there are any threats out there. We don't think they're very likely to occur, and therefore we don't need any rules. But they went a step beyond that, and they said, if you don't buy that, we have a backstop. And so they're compelled, if they're going to say that, to ensure that there's actually a backstop there, and that requires them to identify what conduct they think has to be prevented in order to fulfill the purposes of the statute, and then
And they
engage
have
in
to
a
justify it even if they've given independent and sufficient alternative ground. They say,
Yes.
we would do this rule, regardless of those backstops, we would do it because no one's ever going to need to get to the backstop, given everything else we've put in place, including transparency requirements.
I think that they do, but that's not this case, because they didn't say all these things in the alternative. They said all these things in combination, and they make that very clear in a number of places. One of the things that is in that mix is also the disclosure rule, because they recognize that competition isn't going to do any good for consumers who generally aren't able to know why they can't reach a website, why they're having a crummy streaming experience, because they don't know if it's the ISP making a mistake, if it's the ISP intentionally blocking or throttling, or if it's a problem with the edge provider. So a keystone of their competition analysis is the existence of the disclosure rule. But they've backed themselves into a corner by attempting to disavow every source of authority that might allow them to impose conduct rules. They've left themselves with nothing left to authorize this disclosure rule, except what they cite is Section 257.
Right.
And there are three problems with that, one of which I'm going to leave to the interveners so we don't have undue duplication here. Number one, it wasn't referred to in the notice of proposed rulemaking. It was.
To everybody to advance legislation that one should.
So certainly,
enact.
but here it's.
And some of the people participating on your side offered Section 257.
So let me say a couple things about that. First, it's important to look at the specific governing language from the APA, because the APA has a specific rule for legal authority that is different from the requirements for giving notice with respect to the substance of the rule. Section 553B2 says the notice shall include, quote, reference to the legal authority. It's not enough, as with respect to the substance of the rule, that you simply identify the subjects and issues involved. You have to include a reference to the legal authority. Simply asking the world to comment on potential sources of legal authority is not a reference to the legal authority. The closest they came to in this NPRM was to cite to particular paragraphs in the 2010 order. And they cited paragraphs 124 to 135 and paragraph 137. They could have easily said paragraphs 124 to 137. They did it the way they did to leave out paragraph 136. But 136 is the paragraph, the only paragraph that discussed Section 257 as a potential source of authority in that order. So that is not, by any stretch of the imagination, a reference to the legal authority. And it, in fact, conveyed to the public that 257 was not on the table. And so it is true that they're able to identify, they say, 6 out of millions of comments that address 257. In fact, I think when you look at it, it's only 3, and 2 of those, including the ones by the interveners here in this case, address it only in the context of it being an authority along with other provisions that sidesteps the statutory construction issue that creates the problem here when you rely only on it. But regardless, the fact that a handful of folks commented on it, I think reflects that a handful of people thought the commission made a mistake in not including a reference to 257, not that the world at large understood that 257 was on the table. Regardless, that statute's been repealed. It can't provide a source of authority now. It was repealed before the effective date of these regulations. Now, the commission's only response. What's that?
257C.
Correct, which is,
replaced.
it was repealed. And there is another provision now, I recognize that the commission says gives it another comparable source of authority.
257A wasn't repealed.
Right, but the new provision, well, number one, the commission didn't rely on 257A as authority. 257A gave a time-limited order to hold a proceeding within 18 months of the enactment of 257A. 257C is what they rely on, which said you have to update us on a regular basis by providing additional reports. It was 257C that they relied on for the reporting requirement, and that provision was repealed. It was replaced by another reporting requirement, but it didn't simply reenact it. For example, the new requirement doesn't refer to 257A. And a lot of the discussion in the order's analysis of the reporting requirement, naturally talks about the language in 257A because 257C had cross-referenced it. The new provision doesn't. At the same time, the new provision, part of that legislation says we're not changing or expanding or contracting the FCC's authority, so we have to reconcile the elimination of the reference to 257A with that savings clause. It's not to say that the Commission won't be able to come back and have a similar claim of authority based on that new provision. It's just to say that they haven't done that yet. And the fact that the Commission's counsel thinks they can make that argument just isn't good enough under this court's precedent. That the court doesn't construe these statutory provisions in the first instance. It's the Commission's job, and it's the Commission to whom.
Essentially a Chenery argument.
I'm afraid I don't understand the reference.
Well, an argument that an agency cannot rely on an analysis that it didn't voice in its decision. It has to, it cannot rely on what counsel says in its brief or oral argument. But does that apply to a pure question of statutory interpretation, and why would it? At least to the extent that the interpretation the Commission now relies on is correct.
I'm not aware of any exception to the rule that the court will not consider an argument made in the first instance by counsel for legal issues or for occasions in which you think counsel is clearly right, because the obligation.
I think it's a question of counsel being clearly right. It's a question of whether the extent to which it's purely a question of law.
So look, I could understand an argument if you said the statute is susceptible of only one interpretation, so we're not going to send it back. I don't think anybody's said that here, and I don't think that they could. So long as there is ambiguity in it, Chevron says the agency gets to choose. And that's a choice for the agency to make in the first instance, and that's why we don't accept arguments from counsel in the first instance. If I could turn, and I think my colleague is going to talk about why, if you take down the disclosure rule because of this problem, because of the notice problem, the whole order falls with it, because disclosure is the cornerstone of the rationale for the reclassification decision and for the withdrawal of all the rules. Putting that to the side for the moment, I would like to move briefly to mobile, if I could. There are two aspects of the Commission's rationale for its reclassification of mobile. One is the discussion of telecommunication services that you had in the first part of the argument. And I would like, if I could, to just briefly address that, although I apologize, I know it treads over some of the same ground that you went over last time. And that is, everybody agrees that a offering of a pure transmission service in and of itself has to be classified as Title II. The only way you get out of Title II classification is by integrating into that transmission service some information service. In Brand X, it was the email and the web host.
And various other things, including access to the World Wide Web and so forth.
Let me get to that. That part, the add-on services, has gone away. The Commission doesn't rely on it in its briefing to this court. It more or less abandoned it in footnote 99 of the order. So what do we have left? We do have the fact that computers are used to transport the packets back and forth. That's, of course, true of telephone service today as well. And I don't take the Commission's order or its briefing to be arguing that it's an information service because it integrates telecommunications with that underlying computer processing necessary to transport the packets. So what's left? There are two possibilities. One is DNS and caching. Brand X didn't decide whether those were telecommunication services. And for the reasons that we've already discussed, the Commission didn't reasonably conclude that they fell outside of the telecommunications exception, in part because it relied substantially on a misreading of prior MFJ precedents, which, as my colleague explained, that is just an incorrect reading of those decisions, and they're not entitled to any deference about their interpretation of a judicial decision. In addition, they have...
I don't think they're relying on the judicial decision. I think they're saying that here's an interpretation of these words, and it makes sense.
Well, they tried to justify it as saying this is the state of the law that was on the books when Congress enacted the 96 Act, and therefore Congress would have intended. So I think they have an obligation to be right about what those decisions meant. It's arbitrary and capricious for them to explain that their decision is based on those decisions when it can't be. In addition, it's arbitrary and capricious for them to say, we're going to adopt a rule that DNS and caching don't qualify because they assist consumers, when it hasn't changed, as my colleague said, the classification for things like call forwarding and caller ID. Those obviously are principally there to help the consumer. Why are those telecommunications management exception services, but DNS and caching are not? It can't explain it, it's arbitrary and capricious. So it leaves one more possibility, which is their principal theory, and it's the weakness of all these theories that drove the commission to adopt this principal theory, which is the transmission component itself, sending the packets back and forth, is in itself an information service because it provides you the capability of interacting with third-party websites. And that can't be right, because the definition of an information service says it has to be a service, a capability that's offered via telecommunications, and it can't, which clearly shows that it can't be only telecommunications. Congress expected it to be something else. And that's why this court rejected this argument out of hand in USTA when the other side made it. I realize it's a different standard of review. But the reason that this court gave was that it conflicted with the plain language of the statute to say something that is only telecommunications is also also an information service, because it can't be with a definition that says information services are offered via telecommunications. Setting all that to the side, the commission also pointed to Section 332 as barring classification of mobile broadband as a common carrier service. And its principal reason for doing that was to say that it doesn't offer interconnected service. It didn't dispute this court's and our assertion that was confirmed by the court in the USTA that users do have, mobile broadband users can reach all NANP endpoints so long as they use a VoIP application.
Through a different service. And the commission here relied heavily on the fact that the statute speaks in terms of defining services. That's
correct. And we pointed out in our brief that under their view, if the only thing you're looking at is the service, mobile voice is not an interconnected service, because if I go online and order a mobile voice plan, I can't do anything with it. I have to have a phone that is running appropriate software that is compatible with the phone and the software of the person that I'm calling in order to have actual communications. It can't simply be the service itself that provides the capability. It has to be the capability that is available when used in conjunction with compatible devices running compatible software. And it's always been that case. You can never use a telephone to call a fax machine. You always had to have users using compatible equipment running compatible software. That is why the commission in its reply brief, its commission's lawyers, switches gears and says, okay, the relevant capability is provided by the service plus the capabilities of the phone, quote, out of the box. There are many problems with this. That is a qualification that is not in the order. In fact, it's disavowed by the order, where the commission repeatedly disavows any reliance on a distinction between software that comes pre-installed by the manufacturer or not. So this is at paragraph 80, footnote 298, and at paragraph 81. In addition, the factual premise that mobile phones come out of the box capable of making voice calls but not VoIP calls is nowhere in the record. And in fact, it's contradicted by the evidence in the record, which shows that the majority of folks now, when you get a phone, it's going to be a smartphone, and it's either going to be a Google Android phone or an Apple phone, and both of those operating systems come bundled with VoIP software, FaceTime for Apple, Google Voice or Google Hangout.
You're speaking as if mobile broadband were confined to smartphones.
Well, certainly, go ahead.
But leaving out things like iPads, tablets, et cetera.
That's true, but the iPads and the tablets come with the same software. I can make a VoIP call.
Of course, it can be added.
Right.
But are you saying it's uniformly added?
No, and again, my point is simply to back up to the regulatory question. So this is a question about the interpretation of their regulation. If they read the regulation and the statute as saying we're going to look at the service alone, then nothing is interconnected, because you always have to have compatible devices running compatible software. And the same is true of the old telephone service. So it may be that if you have a mobile broadband connection and you hook it up to a thermostat, you're not going to be able to call somebody on their telephone with it. But that's always been true. It's been true, for example, of one-way paging. One of the other quintessential commercial mobile services has been paging. And you've never been able to use a one-way pager to call somebody on the telephone. It's always been sufficient that if you hooked up that connection to appropriate software, you could make the connection to any endpoint. And that's because what it means, Congress obviously meant for something to be interconnected, is that the service provides a telecommunications pathway to all the endpoints on the NANP, which users can use to communicate with each other, but they have to bring the right software and the right hardware to the connection to the service that they've purchased. We've also, let me move on, if I could very briefly address one other point of the arbitrary and capricious analysis, and this is the rejection of NHMC's request to include in the record the tens of thousands of consumer complaints that the Commission had in its possession. The Commission in its NPRN asked for evidence of problems with respect to internet openness. It had in its possession tens of thousands of complaints that are obviously relevant to that inquiry. If they showed, as the Commission suggests at times, that there wasn't a problem, that goes to the question. If it shows that there was a problem, it goes to the question. The Commission can't keep information in its possession that is relevant to its inquiry out of the record and then come to this court and say, don't worry about it, because we looked at this stuff as it came in and we don't think it's relevant. And in fact, what their actual response is even more narrower than that. And they say that there is no reason to believe that these complaints raise a new, quote, issue that's not already raised in the other comments. But that's not the point. The point of looking at these is to substantiate, is to look for evidence, is to substantiate claims about the issues that the NPRM raised itself. And the Commission has no good reason why it didn't itself put this stuff in the record when requested, much less that it didn't do it when NHMC went the extra mile and got a bunch of this stuff through FOIA, although much of it dumped on them with 6 days to go in the reply period. That in itself, we also think, is just a classic violation of the APA.
But not enough time for them to put it into the record?
Well, there's two problems. Number one, it wasn't. It wasn't enough time for them to go through it. They asked the Commission to put it into the record.
They just want it in the record. They could just put it in the record.
Well, they asked the Commission to put it in the record, and the
No,
Commission
but
said
couldn't
no.
they have put it in the record themselves?
They don't have the option.
They don't have the option?
Because what they were given by the Commission was data files of the sort that you can't simply electronically dump into their comment record system. And so what the Commission did was they said, look, we will take a picture of the thumb drive and we will put that in the record. But it didn't put any of the substance in the record. And to be clear, the Commission didn't say, we're not putting this in a record because you should have gone through some other procedure to get it into the record that you didn't do. It said, we had no obligation to put this stuff in the record ourselves, which is wrong, and that we had no obligation to do it at your request because we've looked at this stuff and we don't think that it's relevant.
We just go back a moment. You did not cite the relevant section of 553 on the question of citing statutory authority.
No, the interveners did. The interveners did in their brief. We relied on the interveners to do most of the briefing on this subject in order to avoid burdening the court with duplicate briefing. If there are no further questions.
May it please the court. Stephanie Weiner for non-government interveners in support of petitioners. Our intervener brief offers the reasons why the Commission's decision to eliminate all of the rules governing net neutrality conduct was arbitrary and capricious. I do want to focus here on Section 257 and the transparency rule because it was the linchpin of the FCC's order and in particular, its decision to eliminate all of the other net neutrality rules. The Commission relied on the transparency rule for finding the rules against blocking, throttling, and paid prioritization unnecessary. It relied on the transparency rule for its finding that those other rules would have zero or approximately zero benefit. And the Commission declined to read Section 706 of the Communications Act, of the Telecommunications Act, as a source of authority over ISPs because the FCC said that it believed that it could protect internet freedom without it. That protection rests, I think it's fair to say, on the transparency rule, and that transparency rule, as we know, rests solely on a single provision of the Act, Section 257. Section 257, by its own terms, affords the Commission no independent rulemaking authority. Section 257 is unambiguous. 257C was a triennial reporting requirement to Congress, and the Commission's position, and to the extent the Court shares this view, it was linked to the inquiry in 257A, in which Congress directed the Commission to conduct a proceeding for the purposes of identifying and eliminating market entry barriers by regulations pursuant to authority found outside of Section 257.
Could you pause 1 second for me?
Yes.
Okay, go ahead. Sorry, go ahead.
Of course. So if you look at the language of the provision, Congress made clear that Section 257 was not intended to be a source of rulemaking authority for anything.
Didn't we say otherwise in Comcast?
In the Comcast case, in dicta, the Court did describe Section 257 as a source of authority potentially, or ancillary authority for disclosure requirements, but the Court talked about regulated entities. In that case, of course, there was a slew of different statutory authorities before the Court. The conduct was quite different. It was an enforcement action. Here, the Commission has disclaimed all other sources of authority over broadband providers. I do not think they fit even within the dicta of the regulated entities that were discussed by this Court in Comcast. In the order itself,
I'm confused. I mean,
Sure.
Comcast was in an era before the application of Title II.
correct.
Right. So it's certainly the suggestion by the Court there that 257 could be used surely didn't depend on the application of Title II authorities.
That's correct, but I do believe that the Court in Comcast was not addressing what would happen if Section 257 was used in isolation. There were a number of other provisions, including, most particularly, Section 706 discussed in Comcast, that should the Commission assert authority over these entities, they may also have authority that would be ancillary to their reporting requirement with regard to market entry barriers.
Is there language in Comcast that ties those two together in the way that you have?
I think the actual quote in Comcast uses the term regulated entities, and that's what I would point you to. And here, having disclaimed all other sources of authority to regulate these entities, all that the Commission is left with is Section 257 itself. And that is not enough. In this case, the Commission doesn't grapple with this in the order. It claims that its authority to, quote, identify and eliminate market entry barriers implicitly empowers it to impose third-party disclosure requirements, but never explains how that can be true when Section 257 says it must look outside the Act. With respect to ancillary authority, the Commission does invoke general rulemaking provisions, but again, to assert its ancillary authority, that authority must be ancillary to something. Under this Court's precedent, the Commission must find that it is within Title I jurisdiction, and also that the exercise of authority is made in furtherance of an expressly mandated statutory responsibility. The only statutory responsibility cited here, Section 257 of the Act, tells the commission that it cannot adopt rules. And this court's decision in
That's on a
EchoStar.
particular reading of the two things involved.
Correct, and I'm happy to
Identifying
get
and
to that.
stamping out.
Yes, and I do think, to get to that, or to finish the thought, obviously you can't use ancillary authority to override Congress's clearly expressed will. In terms of the reading of the statute that is offered for the first time by agency counsel, but does not appear in the order, they have put forth a view that this regulatory prohibition applies only to eliminating barriers to entry and not to identifying them. The agency counsel goes on to claim that the transparency rule only identifies barriers. That's wrong for 3 reasons. First of all, Chenery, Your Honor, this is a post hoc explanation in our brief because it doesn't appear in the order. And with regard to your question about statutory interpretation, we do cite the Kansas City case from this court in which the court refused to uphold in a counsel's statutory interpretation as a basis for agency decision-making. That's on page 17 of our brief. At a minimum, though, it would not be entitled to deference. It is not a product of agency decision-making. Second, the statute itself uses the phrase identify and eliminate, or identifying and eliminating. That's what the order refers to as well. There's no reason suggested why the regulatory prohibition would apply to one half of that phrase and not the other. In fact, doing so—
An idea pops into mind,
Sure.
does it not?
Pardon?
An idea pops into mind as to how one might draw that distinction.
Well,
One, proximity of the parenthetical to one word and not to the other, and second, one being much more drastic than the other.
I'm not sure I agree that one necessarily is more drastic than the other. You could think of an elimination of a
One
paper.
requires affirmative regulatory authority to eliminate something. You don't necessarily have to use affirmative regulatory authority to identify a problem. The commission could do that by itself. So would
That is
be-
correct.
Why isn't that a reasonable explanation?
I think it is correct, and in fact, the commission has always, for purposes of Section 257, conducted a proceeding, had, hearings. It could take surveys, so you are right that there are other means of doing so. However, I do believe reading those, trying to separate them apart, does create quite a loophole, and in fact creates an opportunity to do an end run around the provision altogether. And that is what happened here. If you look at the transparency rule, if you read the order, and in fact the commission's brief, is about eliminating barriers to entry. That's what they say. Its whole purpose is to deter broadband providers from engaging in harmful conduct. It is about informing consumers and edge providers so that they can bring—
Isn't that just an understandable application of Justice Brandeis's famous dictum, sunlight is the best disinfectant?
I do agree with that dictum. However, I do not think that it does enough work for the commission here, given the reliance on the transparency rule and these disclosure requirements as effectively protecting the internet. If the commission just wanted to identify barriers, it could have done a number of things, as Judge Millett suggested. It could even, if you were to buy agency counsel's interpretation, had perhaps a reporting requirement. Here, they intentionally required providers to disclose this information to the public. They looked to that again and again to provide the backstop for ISP's harmful conduct. They looked to the
Can I just clarify,
transparency.
is it to the public or to a customer, subscribing customer?
Well, they are made available in 2 ways, either on an ISP's website or submitted to what the commission refers to as a portal, which is essentially a part of the commission's website where you could go and look up your provider. The point
So
here—
they have to submit it to the commission as well?
No, they do not have to submit it to the
Choose
commission.
one of these 2 options?
The broadband provider can elect, and in fact, we looked when we wrote our briefs. I did not recheck before today, but there were, perhaps a dozen or 2 that chose to file with the commission. Thousands are not doing so. And
Not filing with the commission or not disclosing at all?
they are disclosing on the commission's website. I mean,
On their own?
forgive me, on their own website. They're disclosing, which is permissible under the commission's rule, but the commission is not gathering this information, it's not collecting this information. This, I think, really tells you why they have adopted this rule in the first place, while they are clinging to a congressional reporting requirement to identify barriers. What they are using this rule to do is to affect behavior, to eliminate those barriers, blocking, throttling, paid prioritization, to the extent that even the commission views some of those things as harmful. And that the commission cannot do even under its own reading of Section 257.
One thing the briefing left me unclear about, and that is, how do these disclosure requirements under this rule differ from disclosure under the 2015 order? Or is it, for that purpose, the same?
For this purpose, I believe it is the same. The difference are, the most relevant difference is that, of course, the commission has had a transparency rule in 2010 and 2015. It has never relied solely on Section 257 to adopt that rule.
I'm just talking about the content of the disclosure and the location of the disclosure.
The content of the disclosure, previously, and in 2015, there were some additional pieces of information. Providers were intended to disclose things like packet loss, particular fees. I don't have the full comprehensive list, but the commission did remove those, what were referred to
They
as.
got rid of details about disclosures regarding commercial terms was one of the things that was changed, and that's
Yes, and I
pretty
believe that.
vague language, and so I'm trying to see
An
if there's a material
example.
difference.
An example, I believe there was a requirement in 2015 or discussion of a requirement that providers needed to disclose data caps, for example, and how they would affect, how they were being provided in a particular service. We can confirm that, but I believe that is an example that the commission now believes data caps are not important enough for consumers to know about them in order to make their broadband choices. So there were, I think, a series of fees and fines. Packet loss was definitely among the issues that was, in a brief window, intended to be disclosed and now is not. I think for
Has anybody
purposes,
said that they're doing paid prioritization?
not to my knowledge.
That would have to be disclosed if they were?
Under this order, it would have to be disclosed if they are.
And so, because the rule's been in effect now for 8 months, 7 or 8 months, and you said, to your knowledge, no one has engaged in no one has adopted a policy or practice of paid prioritization yet.
You can confirm that with, I think, intervener supporting respondents. To
Oh,
my
you
knowledge,
said you looked at some of these, so that's why I was at. You said you looked at some of these disclosures.
I
so
have not done so comprehensively.
I assume nobody's disclosed that they're blocking and throttling.
Not to my knowledge, although, I think that one of our position, in addition to 257, is that transparency alone in these disclosures are not sufficient. And in part, that is because it is quite difficult for consumers, even with this information, to understand will harm as it is affecting them as a broadband
One thing I'm trying to
consumer.
understand is, how does the disclosure work? Does it end up just being a new paragraph added to a very long list of disclosures that appear in small single type and, click on the end? Or does the order require that it be a distinct display, easily accessible to the public, to potential consumers, to customers? And maybe sounds like it's no different from what the prior orders were, but it's now being relied on pretty heavily to do a lot of work carry a lot of water by the commission. So I'm really trying to understand what these disclosures look like.
Understood. And I apologize that I'm not able to answer more fully. I do believe that there is language about them being accessible in the order, but I do not believe that they're...
Accessible is a
Is
word
a
of
broad
many
word.
meanings, so.
Exactly.
What does the rule, not in practice, what does the rule, as you understand it, require about how these need to be displayed in a way that customers or consumers, the public, will be able to find them and digest them?
My understanding is that the rule requires that the transparency disclosure be available in an accessible way on the broadband provider's website. Alternatively, the broadband provider may file it with the commission. I think it's fair to say that there is not a lot of precision or that the broadband provider has quite a bit of flexibility in terms of how they comply with that disclosure requirement. Previously, I guess one of the other changes in 2015, there was a movement to try to standardize those disclosure requirements and a sort of a safe harbor where meeting certain requirements, almost like the cereal box, to allow for better comparisons. This order eliminated that standardization. So if anything, it has sort of taken a step back from consumers' ability to sort of get the information that they may need, or an edge provider's ability to get the information they may need. I do want to make the final point that this problem with the transparency rule infects the entire order here. We argued in our briefs that the Commission's transparency rule was inseparable from its decision to eliminate all other rules. The Commission has not disputed that in their brief in response. And in fact, if you look at what they did here, they kept the entire order from going into effect, the classification decision, the declaratory ruling in the order, as well as the decision to change the rules until the transparency rule went into effect months later after its approval by OMB under the Paperwork Reduction Act. And so, in our view, because the transparency rule is invalid, this court cannot sustain the FCC's decision-making that rests on it as a source of reasonable decision-making.
All right, thank you very much.
You're welcome.
Hear now from the government petitioners.
Good morning, and may it please the court. Danielle Goldstein of the County of Santa Clara on behalf of the government petitioners. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal. In this case, there's no real dispute that the FCC has a statutory mandate to consider public safety. 47 U.S.C. 151 tells us that this is one of the reasons for which the agency exists. There's also no real dispute that commenters on this record raise the prospect of harms to public safety that, if realized, could cause damage to property and loss of lives in the event that, for example, a person doesn't receive a timely evacuation order or shelter-in-place order. The FCC didn't address this evidence, didn't even mention it. And so the only real dispute here is whether an order that completely fails to mention the harms to public safety, much less include them in its analysis, can meet the FCC's statutory obligation to consider public safety.
What aspect of the new rule do you think it is that most potentially implicates safety? Is it just you need all the common carrier regulations, or is it the risk of getting put to the back of the line in a paid prioritization scheme?
So, I'm sorry.
I get that there's people complain about blocking or throttling, although one has to hope broadband providers wouldn't actually adopt a policy of doing that for public safety. So where did they fall down?
So on all fronts, really. So blocking and throttling poses obvious problems for public safety, but we're equally concerned about the incidental impact on public safety that might not even be particularly visible to biased providers that can occur with practices like paid prioritization. We're also concerned about the elimination of any oversight authority by the FCC to take on other practices that might be unreasonable. So it's the bright line rules, all of them, and also just the FCC.
So on the latter, broadband wasn't subjected to common carrier regulation until the 2015 order. So were there problems prior to that order for the absence of common carrier regulation for public safety? Or is it really these concerns now about sort of explicitly authorizing paid prioritization, blocking, or throttling?
So we understood the commission to be policing, as we say in our brief, to be policing internet openness for a long time before the 2015 order. And it's also true that the use of broadband in public safety has been on a rapid increase, and we anticipate that it will increase further still. And I would note that both the 2010 order and the 2015 order specifically addressed public safety, which the order here didn't. And so it's opening up the doors both to having no regulator in this space that we can turn to, and specifically allowing practices that allow public safety communications to be moved to the back of the line without any reason for doing so. You know, one of respondents' arguments here.
You aren't saying that in the era before 2015, such putting at the back of the line happened.
I'm not aware of any evidence in the record that that actually happened, but as my colleague Mr. Russell pointed out, it's often not visible why a particular communication is slowed or delayed, and so it wouldn't necessarily be the case that a consumer or a first responder whose information was slowed because of these kinds of practices would have even known. And so I don't think that.
Were there practices of paid prioritization before in the period leading up to the 2015 order?
I'm not aware of that.
I'm just not sure how much of this requires sort of more recent technology to implement or not.
I'm not aware of that. So I want to turn, if I could, to respondents' arguments. Respondents' basic contention is that the FCC wasn't obligated to specifically address public safety because the record reflects no distinct issues that are unique to public safety. So in other words, because the Commission considered the competitive harms to Netflix, it adequately considered the risk of loss of life or property in the public safety context. So they don't cite any case law for the proposition that the FCC can conduct public safety in this way. And Congress, of course, delegated to the expert agency, not to appellate counsel, the responsibility for weighing and evaluating public safety harms. So it's not a proper defense of the order, but it's also an inaccurate characterization of the record. Commenters on this record did point to distinct issues that relate to public safety. And they relate specifically to issues that have been identified as the cornerstone and linchpin of the order by my colleagues. So the first is that after-the-fact remedies are uniquely poorly suited to the public safety context because the harms in the public safety context are truly irreparable. And that's at JA 03333. That's one example. The second is that access to government services doesn't drive consumer purchasing decisions the same way that access to, for example, Netflix does. And that's at JA 03337. And that relates particularly to the concern about the operation of the transparency rule and whether consumers will have enough information and the motivation to self-regulate, essentially, broadband providers through disapproval of certain practices. But these two issues taken together highlight the importance of the rule that the agency consider public safety in its opinion, because taken together they show that the result of the failure to consider these types of factors that are unique to public safety can be, as it was in this case, an order that leaves public safety largely unprotected. So in the course of describing how practices like paid prioritization could affect first responders and members of the community trying to get critical information in an emergency situation, commenters pointed out that the types of harms that could result in these situations can't be remedied even by effective after-the-fact measures. But corrections that come weeks, months, or years after an emergency come too late because crises happen in an instant and the first few minutes of an emergency response are the most critical. That's when members of the community are getting these shelter-in-place or evacuation orders and when first responders are gathering information about on-the-ground conditions. So even if there was an antitrust or consumer protection action, which are the particular after-the-fact remedies that the agency has pointed to here, and it's really hard to imagine an antitrust or consumer protection action that could address these types of gaps, even those actions can't bring back a life or a home. They just don't speak to that situation. And that's especially important because, as my colleagues pointed out, it's those antitrust and consumer protections actions that the agency puts so much weight on. So turning to respondents' claims about what consumers will do here, This was not a claim that was made by the agency. Respondents in this litigation claim that consumers will protect public safety because they will react to media reports or transparency disclosures. But that's even harder to credit. Because consumer choices are a deeply uncertain source of protection when we're talking about loss of lives or homes. Recognition of that fact is part of why we have local governments and the FCC in the first place, and it's part of why the obligation to protect public safety is in Section 151. If consumers were enough to protect public safety, you wouldn't need an agency to do it. But the transparency rule in particular, which was created in a different context and adopted here without any discussion of public safety at all, just doesn't map to the public safety context at all. And this goes to your question, Judge Millett, about what consumers know when they look at these transparency disclosures. Consumers barely know what agencies provide public safety services, much less how they're provided and how a bias provider's disclosure that they may engage in paid prioritization will have an impact on them in an emergency. And furthermore, that doesn't even address the problem that, as commenters pointed out, government services don't drive purchasing decisions for consumers in the bias context the way that access to Netflix does, in part because of that information problem.
So as I understand it, the transparency disclosure just requires that you disclose certain behaviors or practices. It's not like a medical one where you have to tell what the side effects could be of this process. Is that correct? So that even if a consumer look, they're not going to see the consequence of paid prioritization for their Netflix, let alone their fire department.
That's absolutely right. And I think that if you look at paragraph 220 of the order, which talks about what has to be disclosed, there is no requirement in that section that describes what has to be disclosed with respect to paid prioritization. There's no requirement that they say, for example, in an emergency, you may not be able to get your shelter-in-place or evacuation order. And so we think that that's one of the reasons that the transparency rule simply doesn't bear on, it's not responsive to public safety concerns at all. So I want to turn finally, if I may, just to interveners' arguments for a moment. So interveners argue, they take a different...
I'm sorry, just to back up.
Sure.
When you're talking about public safety, because there's another provision of this of federal law that addresses, sort of notices the beeping phones we all get in bad storms, or maybe they happen for wildfires in California, those types of notices. Because that's, I assume, going through the phone system, that is not affected by this rule at all. And so you're only talking about individualized information or what?
So I think you're responding to the emergency alert system, which is a separate, that is a completely separate set of services. I mean, that's certainly necessary, but it's not sufficient to protect public safety because many people, for a variety of reasons, one, because consumers don't get information just through that system, and they don't get information, I'll give you one example. So our public health website will give vaccine stock information in the event of an influenza outbreak. That website was so overloaded during the H1N1 emergency that we actually had to have it mirrored by a different agency. So there are a variety of sources of information that are extremely important for public health and safety that aren't those emergency alerts. And that's what we're really talking about here, is information that's either fed into or coming out of those public safety systems. So with respect to interveners' arguments, interveners take a different approach from respondents, and they argue that the FCC actually did address public safety, just without actually mentioning it. But that's the one way that the FCC actually cannot deal with the issue of public safety, because as this court said in the American Radio Relay case, that doesn't give this court any path to trace in order to evaluate the agency's reasoning. And it doesn't give this court anything to defer to or evaluate. And so it's also, in total, it's also because you can end up with what you have here. Serious unaddressed public safety harms with no meaningful solutions. And for an agency that, in Chair Pai's words, has no higher purpose than promoting the safety of life and property through the use of communications, failure to address public safety represents an unlawful abandonment of that purpose. The agency can't lawfully avoid this responsibility, particularly in an order where it purports to take away the ability of state and local governments to fill the gap themselves.
Thank you very much.
Thank you.
May it please the court, Stephen Wu for the state petitioners. The order's attempt to preempt state laws is beyond the Commission's statutory authority and should be set aside. As with every action that the Commission undertakes, the Commission has no power to preempt state laws unless it can identify either direct statutory authority to preempt or ancillary authority to do so, which is predicated itself upon a delegated source of authority. And the order here identifies neither basis for authority for its preemption provisions. First, there's no express authority for the Commission to preempt state regulation of information services. And the Commission has identified no such provision in its briefing or in the order itself.
And that was not a problem in City of New York.
Well, City of New York relied on a quite different source of statutory authority. I mean, unlike in this case, the City of New York regulation did predicate the agency's authority on a specific statute. That was 624E of the Cable Act. And in doing so, argued that the preemption that followed from that direct source of statutory regulation was necessary for the Commission to carry out its delegated functions. But this case is...
And under Brand X, was it not a delegated function of the Commission to choose between the application of Title II or not?
But the problem here doesn't arise from the reclassification itself, but rather from what the Commission said about the nature of its authority to regulate blocking, throttling, and paid prioritization. And on those practices, the Commission was quite clear in paragraph 266 of its order that it was disavowing. It found no statutory authority that authorized it to regulate in these areas.
Are you saying that no deregulatory move of any kind can support a preemption order?
No, there's an important distinction here that I think provides sort of two different ways an agency can deregulate. An agency can deregulate in the exercise of its statutory authority by saying that in a field that it has the power to regulate, it has decided to withdraw from regulation as an affirmative act of policy. That's clearing the field in a certain way. But the agency did not do that here. What the Commission said was not, we have the ability to regulate blocking and throttling, and we're just not going to do so. What it said in the order was that it doesn't have authority to regulate.
That's after the previous step of saying that it does not believe that the application of Title II makes sense.
Well, that's correct, but it's a critical step here for what the agency next tried to do, which is then to say, notwithstanding the absence of affirmative regulatory authority to act to prevent blocking, throttling, and so on, that it was nonetheless going to go a step further and prevent the states from doing so as well. And I think the critical point...
But you aren't saying that the Commission's approach could coexist with state rules imposing regulatory burdens where the Commission had decided there should not be regulatory burdens.
Well, it certainly can exist in the sense that
I grant you, of course, it could exist.
Right. But
Trump.
Right, but this is the point that's important. I mean, the Commission's withdrawal of its own authority in this field, its decision that it lacks authority to regulate at all, the Commission sort of conveys as having the necessary implication that states must be left out. But a policy decision by the Commission not to regulate in the field does not give it authority to preempt. I mean, under this Court's decision in Comcast, even a statement of policy by Congress is not enough to support agency action. And a statement by the agency that it decides it doesn't want to regulate can't be enough as well. And I think the core mistake that the Commission makes is in construing preemption of state laws as just a necessary implication of its powers. It is not. The states have inherent authority to regulate in this field. And the practices that are at issue in this order are the types of things that implicate areas of traditional state concern, consumer protection, public safety, as my colleague has argued. For the Commission to have the authority to decide in this order that it will preempt states from regulating in spheres of traditional state concern, it has to identify something concrete.
But you aren't saying that the preemption language of the order excludes state consumer protection from the things that the Commission identified as potential problems?
Well, I will answer it in this way, which is that the order is at least ambiguous on that front, and there are statements of concern for the states on how far that order goes. And I'll give you some examples. I mean, one thing that is clear is that the Commission states in a footnote near paragraph 195 that it is preempting state disclosure laws that are inconsistent with the much more limited transparency rule the Commission has now adopted. Disclosure is a classic area of state consumer protection, and a prohibition on the states requiring, for example, more complete disclosures or even disclosures similar to what was previously ordered would be an impediment to the state's regulation in this area. In addition, the other concern raised by the order is its sort of generic reservation. Every time it says, of course, the states can regulate, but they can't do so if it's inconsistent with the federal policies or federal objectives expressed in this order. And the problem with that statement comes from the breadth of how the Commission has described the relevant
I wasn't clear why
policy.
you were calling that vague. I mean, I get it. I mean, you weren't clear, you didn't act like you're certain whether they were stepping on your traditional state powers, but I guess I had read that as directly stepping on any state powers that are deemed to interfere with federal regulatory objectives. Am I not reading that correctly?
No,
That
you're reading it-
separately from the prior statement, which is more.
You're reading it
specific.
exactly correctly, and is why the states brought this petition for review to challenge, in part, this aspect of the Commission's order. And as I said, the problem comes from the fact that the Commission has defined the relevant federal objectives here as being complete deregulation in this field. In other words, deregulation that extends not just to the Commission's own authority, but to the state's ability to regulate these practices. And I mean, construed, I think, in the most natural reading of that language would be to block the states from regulating, blocking, throttling, even through its consumer protection and public safety laws. That's the concern that's raised here. And the reason that's a problem is that, and the
Is
Commission—
this ripe? I mean, how can we really, without knowing the true scope of the laws that, could possibly be preempted, what they do, what they don't do, how they work, how they operate, and exactly what the position of the Commission is going to be with respect to each of those laws? Aren't we just kind of deciding, something too an abstract of a posture at this point, if we were to take this one?
Yeah, so we don't disagree with that point at all, but I think I have two answers to give to that. One is that the specific dispute here is about the validity of the Commission's order, which by its terms declares that state laws are preempted. And that question is ripe because the order is active and it has effect. And under the Hobbs Act, so long as this order's preemption language continues to exist, the states will be impeded from raising preemption as a defense if they're challenged in their own courts or in the federal courts.
But you can bring a petition then, right? It's not that the Hobbs Act says that you can't litigate this later. It just says that you can't litigate it in state court or as a defense in other litigation later, right?
That's correct, but the court should not minimize the burden that this places on states who will find their duly enacted statutes enjoined pending either the FCC's consideration of a preemption petition or a court challenge to an FCC order about preemption. That is a very unusual and stark difference from the ability of states generally to defend their own laws under a presumption that what they've done is constitutional. But I do want to make clear that we do agree that the general question of conflict preemption is something that should be addressed in later proceedings. But for that to happen, this court should still invalidate the order's preemption language. I mean, to the extent the order relies on a conflict analysis at all, I think what it reveals is that a conflict analysis, whether it's based on Congress's statements or even on the contents of this order, does require facts specific to the features of the state law in question or to the practices that the ISPs are allegedly being regulated. And those facts will matter to the preemption analysis because they determine both what the relevant federal objectives are and whether there's any meaningful interference with it from what a state has done. And because those proceedings, those questions should be resolved in subsequent proceedings, the right thing to do here is to clear this order, which is an impediment to that litigation,
Are there
and allow the
state-
states to challenge.
Are there state policies in effect right now that I guess you states collectively, not just your particular client, have in place that you would think are consistent with giving the federal government control over interstate communications. So they're addressing intrastate issues and intrastate communications or intrastate consumer issues that would now be, that were not preempted before last June and are now preempted under this reading.
Well,
Or under this, I'm sorry, under this reading, under this declaration.
well, I don't want to commit to a defense of some of these state laws.
Some person might say would be preempted under
Right.
this. Is it an issue now, or is it with policies that would come into existence?
Well, it's an issue now in this sense, which is that several states have already enacted statutes to govern various aspects of what you might call violations of the open internet. And that in California, for instance, which passed one of these sort of broad statutes, the federal government and the ISPs have already sued and obtained a preliminary injunction against the implementation of that statute precisely because of the Hobbs Act and the argument that this order on its own preempted that state law from coming into effect. And so that is a sort of ripe controversy for the states. I would say this, the question for this court, I think, is not whether sort of any state law might be able to survive a preemption analysis here, but rather whether the federal government's, the FCC's argument that there is somehow a congressional policy against any state regulation in this field altogether is supportable. And our argument is that it is not. What they rely upon here principally is the jurisdictional provision in Section 2 of the Communications Act. But that provision does not, in its plain terms, speak at all to the limits of state power. What it does instead is it defines the Commission's power to act. It says the Commission has jurisdiction to act over interstate communications, and it bars the Commission from jurisdiction over intrastate communications. But what is clear is that the Section 2 jurisdictional provision does not by itself give the Commission any affirmative authority to regulate, let alone the affirmative authority to do a particular type of regulation, which is the preemption of state laws. And for the Commission to do that, what it has to do is instead be exercising a delegated source of power. In fact, there are good reasons not to read Section 2 as broadly as the...
I'm now trying to recall what you said to my suggestion that they were exercising under Brand X a delegated source of power to make a classification.
Well, but the reclassification is one of the exercises of their power, but the question is whether they have a delegated source of power they've identified for the blocking and throttling practices that are at issue in this order, which is what the states are most concerned about. I mean, to put it maybe a different way, whether the Commission can or cannot reclassify under any provision of the Communications Act is not the concern for the states for preemption. The problem here is the Commission has says we do not have authority, statutory authority under our constitutive statutes to prevent these ISPs from blocking and throttling and so on. That's sort of plank one of their argument. And then they go to plank two and to say we are also going to stop the states from regulating in this area. And I think the best way to understand our argument is that those two propositions cannot be stated at the same time by the Commission. If they lack authority to regulate what they acknowledge are certain abusive practices that require a response, they cannot also prevent states from acting in this area.
Are you saying that you want us to write a decision that says that the FCC has no authority, zip authority to preempt state law in this area?
No, that is not the breadth of the order that we are asking for. What we are asking this court to find is that when the Commission has itself acknowledged that it lacks statutory authorities to regulate certain practices, it has, by its own admission, therefore does not have the authority to preempt state law over those same practices, I mean, we're not trying to fight against the weight of authority that says that there is preemption authority on the behalf of the Commission when it's acting in the exercise of its delegated powers. And I think one model for the way this order should look is this court's decision in the All-American Telephone case, where the Commission, through an order, decided to issue an interpretation of state law and ruled on a question of like a common law claim that was raised in a separate state court litigation. What this court held was that the Commission has no authority to opine on the meaning of state law or state defenses in a separate action, invalidated that portion of the analysis, and did so because of the specific reasoning that the Commission was using in that case. And to be clear, this is not a novel theory of the scope of the agency's authority. It draws from what this court has long held to be the prerequisites for the agency to act at all, and what it specifically held in Narok 2 to be a precondition for the agency to preempt state laws. I mean, in the absence of an explicit statute that says the commission can preempt state laws, and there are other provisions that say that, not for Title I. In the absence of such a provision, the commission has to be acting in the exercise of its ancillary authority, and that ancillary authority has to be tethered to something affirmative.
But what about the impossibility exception? I mean, as I understand it, what your friends on the other side will say is that, look, we've made a determination that broadband service is information service, and so based on that, we are affirmatively prohibited from implementing any sort of regulation that's a common carrier regulation. And so it would naturally follow from that, under the impossibility exception, that the state and local governments can't regulate in a way that would be tantamount to imposing a common carrier regulation. Because if we can't do it, then they shouldn't be able to do it either, especially given the federal policies that are at issue here. What's wrong with that argument?
So there's a couple of answers to that. One is that the impossibility exception itself is an exception that applies when the commission is acting sort of affirmatively under some source of authority. I mean, what the impossibility exception allows the commission to do is, when it is exercising some lawful authority, to sort of override the general prohibition on interstate regulation if it's necessary to do so to defend some exercise of statutory power. And again, the predicate to that exercise of the impossibility exception is what is missing here. They said they don't have the statutory power to regulate blocking and throttling. And I should say the argument that the commission makes, that there is some sort of free-floating impossibility exception as a conferral of preemption authority, isn't supported by the case that they cite. Louisiana PSC, which possibly originated the impossibility exception, was a case that in its actual holding sort of insisted that the agency defend its preemption there on the basis of a statutory authority, and said quite explicitly that even if there's some argument that what the states are doing is in conflict with the federal policy, even if there is such an argument, the commission still cannot preempt unless it does so from authority that Congress has conferred to it.
What about congressional adoption in 1996 of the Telecom Act in the face of FCC preemption of enhanced services? State regulation of enhanced services.
Correct, but even assuming that there was an incorporation of those past practices, what the FCC has done here is different.
I mean, City of New York relied on the fact that there had been a history when Congress acted.
Well, there's two answers to that. I mean, one is that the nature of the preemption that the commission is engaging here is not the same as the practice that existed for enhanced services that was assertedly incorporated in the 1996 Act. And I'm going to sound like a broken record when I say this, but the reason is because, as this court explained in Comcast, what the agency did for enhanced services before the 1996 Act, in the CCIA decision, for example, was to identify an underlying basis of statutory authority, for instance, under Title II, and to justify preemption as ancillary to that underlying power. And the commission here has done a different thing. It has said we have free-floating power to preempt in the absence of underlying statutory authority. And the other distinction, and the reason the City of New York parallel doesn't work, is that in City of New York, what the Congress did when it enacted the Cable Act was to recognize the specific source of authority that the commission had in its previous decade invoked as a basis for preemption. That's what 624E was. But in this case, there is no such specific provision in the 1996 Act that reflects what the commission relied on in its previous preemption rulings. I do want to make a more general point, I think, about the relationship between federal and state powers here. And one of the assumptions that is underlying the commission's reasoning, both in the order and in its brief, that a necessary consequence of withdrawal of federal power is the absence of state power too. That, for instance, when Congress limited the federal agency's jurisdiction, it meant to keep the states out of it as well, despite the absence of any express language. And that just runs counter to fundamental principles of what federalism is meant to accomplish. Ordinarily—
Not necessarily in the sense that, I mean, in general, we say that agencies can't act without some sort of, well, we don't say in general, we say very specifically, they can't act without a specific source of statutory authority. And so if Congress says you can impose common carrier type regulations, but only under these circumstances, and if the agency finds that those circumstances aren't present, isn't it a kind of an anomalous situation to say that, oh, the federal agency couldn't, but state and local governments can just have at it and promulgate all of the common carrier type regulations they want, notwithstanding the fact that Congress said explicitly that they wanted the internet to be deregulated, be free from regulation.
But
isn't there something wrong with that picture?
But if Congress had said that explicitly, in other words, used language that applied not just to the federal agency, but by its terms applied to the states as well, we would not be in this situation. And there, again, are provisions of the Communications Act, including for communication services, where Congress did speak expressly about what states and local governments could do for instance, common carrier services. But Congress did not do so here. I mean, one of the provisions the Commission cites, for example, is 15351, the definition of telecommunications carriers. And that provision expressly says that telecommunications carriers can't be regulated only under this chapter, except to the extent that they are providing telecommunications services. That's a direct link to the federal statute that does not speak to what states can do. And again, it runs counter to the general principle that when federal power is withdrawn, it is done without prejudice to states filling the gap. I mean, one of the principles of federalism is you don't have federal power precisely so that states can regulate in this area. And it makes sense as a policy matter because federal regulation is often uniform, may not account for individual circumstances, and state and local regulation instead is quite different.
Even where the federal policy, it's clear that interstate communications is to be within the federal realm as opposed to the state and local realm.
Well, but not to the exclusion of state and local governments. I mean, again, Section 2's jurisdictional provision says that the Commission has jurisdiction over interstate communications. There's no dispute about that. But we know from this court's cases that that conferral of jurisdiction does not give the Commission any power to act in itself. If it did, the rest of the Communications Act would be unnecessary. They need to find some other source of authority to act. An argument here is that by defining the limits of the Commission's jurisdiction, Congress also did not mean to displace what the states could do. I mean, when Congress wanted to do that, it identified specific provisions in the Communications Act, and they're not uncommon, that says what state laws are preempted and which ones are saved, and how the Commission can go about preempting those state laws.
Let me just clarify, you're not saying that states can step in and do interstate regulation when the Commission decamps from interstate, that's done. The question is whether states can regulate within their wheelhouse, intra-state, am I right?
Well, I will, yes, with this qualification, right? I mean, I think a lot goes into the debate over whether something is interstate or intrastate. And I think part of our concern here is that the way the Commission has defined in this order what it means to be inconsistent with their federal policy sort of vastly expands what's meant by an interstate communication into areas of traditional state concern. I mean, they apparently—
You're not saying states are asserting the right to regulate what the states themselves would call interstate communications. There's no federalism history of one state regulating an entire region or the entire country. The states will have to establish that what they're doing is within their intrastate wheelhouse.
Well, let me answer in this way, and I'm not trying to avoid the question. Let me answer in this way, which is that the state's regulation, the type of state regulation that we're talking about here, are things like disclosure requirements, unfair business practice regulations, discriminatory business practices, like core practices that affect state residents. And what we are arguing here is that the states, and we will argue in further proceedings, is states should not be preempted from those regulations, even if they touch upon providers that provide interstate services, like the broadband providers here, and even if to some extent there's an argument that there's going to be compliance that would require changes to interstate communications. And I think the reason I answer it in that way is that there are, I think, both litigants and potentially the Commission that would deem that connection to an interstate communications provider
I get
to
that
be
there will be
interstate
fights in the
communications.
future about whether somebody's coloring outside the lines, but
Correct.
I mean, there's a lot of law on when states can have different standards, even if people will complain that we can't comply with different standards, so for under preemption. But I just want to be clear that when we're talking about the Federal Communications Commission determining that there shall not be interstate regulation, what you're trying to reserve to the states is the state's traditional ability to regulate within that state.
This case is about the state's ability to regulate in core areas of state concern. And I think the force of our argument derives from the fact that what the commission is trying to do here is to preempt the exercise of state police powers. And that's why the two pieces of our argument is, one, the commission doesn't have authority to do that in this order. The order should be invalidated. And to the extent that there are questions, which you are correctly pointing out, about the boundary lines between where the commission's power ends and where the state's power begins, those are questions that should be addressed in litigation arising from specific state laws regarding specific practices regulated by the states in future proceedings without the impediment posed by this order under the Hobbs Act.
All right, thank you. We're going to take a 15-minute recess.
Your Honors, and may it please the Court, Tom Johnson appearing for the FCC. The Supreme Court in Brand X and this Court in U.S. Telecom have held that the Commission has the authority to do precisely what it did in the Restoring Internet Freedom Order, to classify broadband as an information service under Title I of the Communications Act. The petitioners here simply are trying to relitigate Brand X. The petitioners also repeatedly second-guess the Commission's reasonable policies and predictive judgments about how best to promote broadband deployment to all parts of the country and to protect an open internet. None of these arguments have merit. I'd like to start with classification. The Commission reasonably determined that broadband offers the public a single integrated offering, internet access, with each of the 8 capabilities set forth in the definition in Title I. This interpretation was consistent with the interpretation of the court that administered the AT&T modified final judgment, from which the information services definition was derived by Congress in its application to early gateway services, which were conduits to third-party information databases, as well as the Commission's 98 Stevens report to Congress, in which the Commission said that broadband offers internet connectivity, the ability of the user to retrieve, utilize, and make available information. And this theme was repeated throughout the Commission's early classification decisions. Web access, the ability of the user to access the World Wide Web, including third-party content, was viewed by the Commission as an information service capability. And the Supreme Court in Brand X affirmed that as reasonable. Contrary to what petitioners argue, the Supreme Court did not rely on the walled garden model or on the mix of services provided by the provider or by third parties. The Commission, the court said and repeatedly affirmed that when a user uses broadband to access third-party content on the web, he or she is equally using the information processing capabilities of the broadband provider.
So Brand X did not involve interpretation of the issue capability, and that's what the commission has relied very heavily on in this rule. So that, you agree or don't agree, is a whole new issue for us.
Your Honor, I do think that Brand X, I think there's two parts of Brand X. I think Brand X does affirm the reasonableness of the Commission's determination overall that broadband is a single integrated information service, and it relies on all of the authorities, the background authorities that I was just discussing. Even if this Court didn't think that Brand X
But
bought...
that wasn't my question. The question was the specific interpretive question about the rule of capability, right? That was not at issue in Brand X.
Your Honor, you're correct that the focus there was on the definition of offering.
Was this argument even made in Brand X? Maybe the Court didn't address it?
Yes, Your Honor. Again, when the Commission is citing back to its analysis in the Stevens report and in these early classification decisions, it's making that argument that Internet connectivity itself is an information service capability offered by broadband. The fact that a user is
Under
able
that
to...
theory, and it has to be a service that's provided via telecom, what's the via telecom part of the Internet connectivity that you're talking about?
Yes, Your Honor. So contrary to what petitioners say, we address this directly in paragraph 52 of the order and the footnotes thereto. We acknowledge, and everyone at this table agrees, that there's a data transmission component to broadband. The question at issue in Brand X was whether that that transmission component was offered on a standalone basis by the provider, and that is the question on which the Supreme Court said that in this complex and technical area, we defer to the expertise of the
What I'm
Commission.
trying to understand is what is in the capability that's different from the via telecom? When we're addressing this question that Internet connectivity is the capability that makes you an information service.
Yes, Your Honor. So I think that these are broadly worded provisions that the Commission can reasonably construe. And so it's an offering of a capability for. And so the Commission can determine what it is exactly that the service is providing to the end user. And all of those functionalities are common functionalities that end users...
No, I'm sorry, I think I'm not being clear here. Tell me technologically, between this computer and if I were on the internet, which I'm not right now, what function would provide me the capability that makes it an information service that is different from, maybe your answer is it's not, distinct from the function that is the via telecom?
Yes, Your Honor. So I think for the purposes of this argument, we're not saying that there's something technologically different. It's the broadband service itself. But the question under the Telecommunications Act is what capabilities are being provided. It's a qualitative analysis, Your Honor.
Well,
And
it's
if you
what
remember,
qualification, what functions are being, capabilities are being provided via telecom?
correct, Your Honor. And so the question in Brand X was telecommunications being offered on a standalone basis? So if you remember the history here, Your Honor, is that it oftentimes was common for, during the early days of the internet, for a consumer to have one provider who offered the dial-up connection to the internet, and another provider would actually give you internet access. Those were non-facilities-based providers. By the time that you get to Brand X, you had facilities-based providers providing both. It's not a question of what the third-party content. Everyone understood the third-party content was not being provided by the provider. But the question is now you had both transmission and access to the internet in a single package. And so the question for the court, and they said the commission gets to decide, is whether these two things combined were a single unified offering or not. And Your Honor, again, this wasn't adopted in a vacuum. Under the 96 Act, There are two categories, one of which were traditional telecommunications services, the other were these emerging computing services called information services, and the Commission has discretion to look at those two categories and determine whether there's a single information service or whether there are two services that might require different regulatory treatment. And so
What
that's
exactly is the
basic.
computing service? What do you mean by that? That's, again, distinct from the transmission.
No, Your Honor, I'm referring generally to information services. There were a whole suite of emerging services at the time, and one of them that was key to the, or was highly analogous here, were early gateway services that were interpreted by the court administering the AT&T final judgment to be information services and required a waiver from that judgment in order for the Bell companies to offer it. But Your Honor, we also bring a second argument to this court, which is also fully supported by the Brand X decision, which is that even if you think that the provider needs to be providing something technologically in terms of information processing capability itself, we rely on the same information processing capabilities at the
Well, I
Supreme.
didn't mean to push you into argument B. I'm really just trying to understand if there are two different aspects to this internet access connectivity that is offered by broadband, one portion of which provides the capability, and another part you recognize is the transmission, or is it just telecom itself? What you're doing via telecom is the exact same thing that is the capability.
Well,
So you're providing telecom via telecom.
Well, Your Honor, there's nothing technologically different that we are relying upon here. But this is the key ambiguity in Brand X. In other words, the question is the provider merely using telecommunications in order to provide these capabilities, or is it offering telecommunications on a separate standalone basis apart from internet access? But again, Your Honor, I mean, there is a second argument that is available and that the Commission makes here, which is fully supported by the Brand X case, which is that domain name service and caching are functionally integrated components of broadband, and they're the same components that the Supreme Court relied upon as well.
I wanted to ask you about that.
Yeah.
Both the Stevens report, the underlying order in Brand X itself, the current order, have these long lines of things that are being, to which access is provided by computer processing, information processing, and so forth. It comes in about 4 different formulae. And what I wanted to know is whether you're relying on anything besides DNS and caching, or just DNS and caching. I think something besides, but I'm not 100% sure what it is.
Yeah, Your Honor, we rely on DNS and caching as determinative. We do note that providers do provide other sorts of integrated functionalities, but we think that DNS and caching are determinative here. And in terms of that list you're talking about, Your Honor, in the Stevens report and in the early classification decisions, this falls under that bucket of internet connectivity, that these are functionally integrated information processing components that permit an end user to access and navigate the internet. And contrary to what the petitioners claim, there was no evaluation here of the mix of components, that DNS and caching needed to be weighed against other offerings made by the service provider. They were independently found to satisfy the statutory definition, and in the cable modem order itself, which was the subject of some discussion, the Commission said that a provider does not need to provide every one of these information processing capabilities. It doesn't matter if the end user uses every one of these information processing capabilities. It noted, for example, that virtually everyone uses DNS. It wasn't relevant to the ultimate conclusion. And Judge Wilkins, this also sort of resolves a practical issue that you identified in some of your questions. The approach of the Commission here, which is consistent with Brand X, means that broadband is a functionally integrated information service and classified the same way, regardless of whether or not a particular provider might offer content in addition to the typical processing functionalities of broadband.
In the order, it talks about, and I think Brand X said the same thing, the transmission comes in connection with the further processing of information. So there's transmission and further processing of information. Can you explain to me what that further processing is and where the order identifies what that is?
Well, Your Honor, I think that it's sufficient for those purposes if you, for the commission to rely on domain name service and caching. So domain name
DNS and cache, or what you
Correct,
talk
Your
about, the further processing.
I don't read Brand X to require further processing beyond DNS and caching.
No, I'm asking what that was a reference to, and you're reading that
I would
both in
need-
your order and in Brand X is just referencing the DNS and caching.
Well, that's correct, Your Honor. They may have been referring to other things. I mean, but
Well, your order uses that same language, so we don't have to speculate about what the court meant in Brand X. When your order referenced further
Yes, Your Honor,
processing,
we're-
that was DNS and caching and nothing more,
yes, we're talking about DNS and caching, Your Honor.
exclusively.
Those are the only two that we say are determinative, Your Honor, yes.
Is that what you
Yes,
mean
yes,
when you
Your
say in your order further processing?
I would need to see what paragraph you're referring to, Your Honor, but the information processing components of broadband that we are relying on here are DNS and caching. And so, to address, I think, part of your question, Judge Millett, these services fully satisfy the definitions of an information service. At DNS, for example, it generates queries to other servers, it stores and retrieves domain name information, it translates domain name information that is provided by the user into an IP address and back. And with caching, caching stores popular content at local servers that users can then access, and so it satisfies the storage and retrieval functionalities as well. Now, the only other response that the petitioners have to the Commission's reliance on DNS and caching is the telecommunications management exception. And what the Commission reasonably concluded was that that exception, too, was derived from the modified final judgment, and that the court there applied a test that it should be read narrowly to apply only to internal management functionalities, not to functionalities that provide a benefit to the end user or that are primarily aimed towards the end user. And it's not correct, Your Honor, that this was merely a position of the government. Judge Green, and there are several orders that need to be read in tandem here, but he applied this test to relay services and determined that those services supplied significant additional functionality to the end user. And, Your Honor, this is an issue of network functionality that falls within the Commission's core area of expertise. And what it did was it found that DNS and caching primarily offer benefits to the end user and were different from purely internal management protocols like the simple network management protocol that actually manages transmission, actually monitors performance or checks for packet loss, authenticates packets, or different from potentially back office functions like accounting and billing systems that would be considered primarily internally facing. The Commission recently determined here that these services did not merely manage transmission, they provided additional enhanced functionality to the end user. And we reasonably concluded that this test was preferable because of the identical statutory language to the loose analogies in the 2015 order to adjunct to basic precedent. If the Commission has no further questions on that, I'll proceed to talk about if the Court has no further questions on that, I'll proceed to talk about the public policy case that we set forth for the reclass.
Can you explain how your definition of capability doesn't extend to telephone?
Yeah, absolutely, Your Honor. So the Commission adopted the same reasoning here that it did in the 2002 cable modem order, which it said that cable modem service always and necessarily offers information processing capabilities in connection with transmission. Contrary to that, the telephone service has been used as a transparent, has been considered by the Commission to be historically a transparent transmission pathway.
Historically or currently?
Currently, Your Honor, there's no doubt that telephone service is a Title II service. It provides transparent transmission. It's offered on a standalone basis. That's another takeaway from the
What does transparent transition mean? Do you mean only transmission?
Yeah, transmission of information from point to point, Your Honor, which is the statutory definition. And so what you expect in an ordinary telephone call is to be able to speak clearly back and forth. And other indications in the Act confirm that telephone service has to be a Title II service. There are provisions dealing with inter-exchange agreements. There are provisions dealing with telephone.
So I get that. The
mergers.
question is whether, so this is not a question about telephone status under Title II. The question is whether your order's interpretation of the word capability is reconcilable with the rest of the statute's treatment of telephones.
Yes, Your Honor, and our interpretation of capability is consistent with the idea that when a consumer is accessing the internet, that is a fundamentally different experience than making a telephone call.
And please explain that to me.
What's that, Your Honor?
Please explain that to me.
Yes, Your Honor, because you're able to, it's essentially akin to early forms of online database access, that you are able to retrieve, store, and use information. And
You can
as well as-
retrieve and share information over phone.
Yes, Your Honor, and that argument was presented by the challengers in Brand X, and it was rejected. They said, what if the telephone service was used to access a time of day announcement? And the Supreme
Yeah,
Court
but that's because we
said,
weren't addressing this capability issue interpretation in Brand X. So for your capability, and that was the offering discussion, so on capability.
well, Your Honor,
They both have the capability. You have the capability of acquiring information, receiving information through a telephone.
Well,
as
again,
much
Your Honor,
as
I think
through-
under the broader theory, these are broad statutory provisions in which we are able to make different classification decisions based on the fact that we're talking about different services here.
That's what I'm trying
And
to
in
figure
the-
out.
and in the-
You're talking about different capabilities between phones and if someone uses FaceTime.
Yes, Your Honor, we just don't think that phone service and offering a pure transmission pathway for ordinary voice communication offers the same dynamic experience that broadband does in accessing the internet. But in addition, it also offers.
I hear you saying those words, and I don't mean, I'm really trying to make sure I'm understanding what the difference is, because people use telephones to acquire all kinds of information on plenty of things.
Again, Your Honor, I think the language is ultimately ambiguous. What the telecommunications service definition says is transmission of information. So no one's denying that information is going back and forth. But again, I mean, this court, indicated in U.S. Telecom that this was ultimately a question for the commission to resolve at step 2.
I understand, but you have
And
to
even the-
resolve it in a way that's consistent with the rest of the statute. And so I'm focused here on your definition of capability. And that, I'm having a lot of trouble understanding how that doesn't, by the very way you've read it, sweep in telephone. And when I just say, well, that's just ordinary transmission, I don't understand that, because we have plenty of ordinary transmission going on with the internet. 2, it's just that you also, as you have said, can acquire information, share information with other people.
Yes, Your Honor. I mean, I think, again, it's a broad definition where the commission is classifying this according to what the uses are. I think the capabilities are the uses that consumers make of the service. But again, I mean, we'd be happy for the court to affirm on the alternative basis that DNS and caching are also functionally integrated, vital information processing components of broadband. That also distinguishes the traditional telephone service.
Sorry, so you don't have any, I'm sorry, you can't help me anymore on why telephones aren't covered? There's something, is there something, it could just, I just maybe don't understand something about the difference in the technology. Does it have something to do with the further processing, but you said that's just DNS and cache, but I'm not quite sure why that would, having a if you think of DNS as essentially a translator, that can't be the difference.
No, but I mean, DNS, Your Honor, has much more functionality than that, Your Honor. I mean, again, in all of the different ways that it is capable of storing and retrieving. And
But the statutory text, and I guess I didn't read your order, is saying how much information you can get is what matters. You can get more information going over the internet than you can going over the telephone. Is that? Because the statutory language, so is that the ambiguity capability is some access to an amount, a quantum, a higher quantum of information?
no, it's not amount, Your Honor.
Okay.
It's the functionality that the end user has in navigating the internet, in having access to email, websites, the ability to create and generate content. Again, we're not saying that.
That's in the ambiguity of the word capability?
Yeah, I think that's a broad enough language to give the commission discretion to interpret it. And again,
No,
Your Honor,
I get,
first
so the
court-
fact that you've identified an ambiguous word that lets you interpret, I get that. I understand your argument on that. And then now, what that means is that it can have different meanings, the word capability. So that's what I'm trying to pin you down on, to distinguish telephones and computers. And I thought the example you gave me as to what you meant by capability having different meanings was that you can do get to a lot more information when you have internet access than when you have telephonic access. And if I
Well,
misunderstood
that's
you, I
right. I
really
would
want
just
you to have the
put it
chance
a
to
little
explain
bit
yourself.
differently. I think it's a lot more functionality, and the fact that, again, as the court said in Brand X, the fact that the telephone service is occasionally used to access things that we might consider to be apps like.
Really? No. I mean, telephone service is constantly used to acquire information
Well, again,
and
Your
to
Honor,
share information.
well, it's used to transmit information, Your Honor, and again, that is the key ambiguity.
Not just to
in the
transmit
statute.
it, they've got to want to acquire. If I want to get information from my pharmacy, I'd like to have something refilled, I can call over the phone, push buttons, and eventually I will have a prescription refilled. I can also go on the website and type in to the doctor's office, I'd like a prescription refilled, but it seems to me the exact same functionality. One is voice and one is typing, but that can't be the difference.
Well, Your Honor, again, we don't think that the limiting principle that the Supreme Court agreed in Brand X was always and necessarily, and whether you view that through the lens of the functionalities that the end user is provided through essentially online database access, or if you view it through the lens of the information processing capabilities of DNS and caching, that is a finding that the Commission made in the 2002 cable modem order and was affirmed by the
So
Supreme Court.
it sounds like you can do
That's
more
not-
information acquiring through internet access than you can through the phone.
I'd agree with
the
you, Your Honor,
quantum
but I think I do think it's difference in kind as well as in degree. That's the only distinction I would make.
I thought the commission relied, at least in part, on the final clause of the definition of telecommunications without change in the form or content of the information as sent and received. And if I understand your argument, it is that with respect to information services, there's all kinds of changes in form and content, whereas with respect to a phone call, I speak, someone listens, and vice versa.
Yeah, no, that's absolutely correct, Your Honor, and I think DNS and caching are the prime examples of that additional functionality.
No, but you provide telephonic service for people who are hearing impaired, and that's deemed to be a telecommunications service, and that involves sign language interpreters. And so it does involve translation of language between people. It's not simply one person hears the words on the end, but that's telecommunications aspect of phones.
Your Honor, but I think, I think, Your Honor, we can go back and forth on this, but I think that, the Commission is the Commission is entitled to regulate these two services differently, at least in part because there are significant, different regulatory consequences to it. And so we don't need to pretend that the traditional telephone network which is, a largely, static network that came from an era of monopolies ought to be regulated the same as modern information services. And so the point is, Your Honor, that when there is this statutory ambiguity, it doesn't need to rely entirely on these underlying technological distinctions that we're making, but just based on whether there are different services here with different service characteristics and that ought to be regulated differently.
Right, and that's what I'm trying
perhaps
to
that-
understand is what the different service characteristics are. And that is, there's a mechanical one, right, which you're using mechanically to communicate with. And
And then there are additional
there's just
information
more
processing
information you have
capabilities.
access to with the
Like-
internet, just to make sure, right? Is that
Yeah,
what?
well, I would say always and necessarily, Your Honor. I would say that whenever an end user browses the internet, that is those are the principal reasons, if you look at the definition, why the end user is doing that, as opposed to making a telephone call.
Well, Brand X uses the term always in connection with the computer processing, et cetera.
That's correct, Your Honor. If possible, I'd like to move on to the public policy case for the Commission's actions here. So what the Commission determined when it took a look at the evidence in the record and the significant additional evidence in the record after it noticed the Restoring Internet Freedom Order, and it made a fundamentally different policy determination than the prior Commission. What it determined was that the principal threat to internet freedom was not the possibility for blocking and throttling by large service providers, of which it found very little evidence and highly contested evidence in the record, but was instead the fact that many Americans don't have adequate access to broadband at all. And what the Commission determined was that the Title II rules were affirmatively harmful in this regard. The Title II rules were depressing innovation and investment and deployment, particularly in those areas that rely on small and rural service providers in order to get access.
And the evidence of a slowdown in the rate of investment in this area, is the evidence, Commission's evidence, causation or correlation?
Your Honor, we would say causation, and I think if you look at the evidence that we put forward on that point, the two studies that we primarily relied upon to support our theory that Title II depresses in innovation and investment were not based only on the 2015 to 17 period, but were based upon historical data about the threat of Title II, as well as the historical treatment of DSL service versus cable modem service. But in addition to that, Your Honor, which confirmed our general economic theory that these sorts of conduct rules and the overhang of Title II regulation depress innovation and investment generally, we had significant evidence from service providers, especially small service providers, who said that their regulatory compliance costs were going up, that they were foregoing deployment, new deployment in underserved areas, that they were foregoing the use of free data plans, which were cast under a significant legal cloud by the prior Commission. And so the Commission determined that preserving Title II, that any potential benefits of that, particularly in light of the sparse evidence of harm, were not justified by the costs. And
And is that your answer? Because the other side says, well, here's all these ISP executives who put out public statements or told their investors that this isn't going to affect, when the 2015 order was coming down or came down, this isn't going to affect our investment. And it sounded to me like you're focusing on the impact on smaller broadband providers or smaller ISPs.
Yeah, well, 2 points to that, Your Honor. It's certainly one of this Commission's highest priorities to close the digital divide. And so one significant benefit that the Commission relied on in this approach was that it would incentivize deployment into these harder-to-reach areas. With respect to the large service providers, though, Your Honor, there was evidence that the chilling effect of Title II was also causing them to forego projects. And what the Commission found was that in light of that evidence, Your Honor, we deemed the comments by some of the CEOs to simply be ambiguous and not as probative of the effect of the Title II
I don't know what was
rules.
ambiguous about this not going to affect us. We're going to keep going ahead.
Well, I think, Your Honor, projections made by CEOs and investor calls are just not evidence that we found as important as.
I mean, they have to be true.
Well, no, that's certainly true, Your Honor. But when we rely upon, when we.
No, I mean, that would seem pretty good. I mean, it's almost like someone doing something under oath, right? That's pretty good evidence if there's a penalty if they're lying or even engaging in misleading puffery.
I understand that, Your Honor, but even if particular companies did not have plans to stop deployment, the question here, I mean, it is within the Commission's reasonable predictive judgment to determine what is the optimal mix of policies. And what the Commission relied upon here were comments, for example, by Charter and Cox that they were stopping work on projects on account of the Title II order, as well as I said, all of the evidence by the smaller and rural providers that we were discussing. I also want to say a note about the sort of the role of competition analysis in this case, since this has come up. So, what the Commission did here, which is consistent with what prudent rulemaking does, is we considered the regulatory baseline here, which is competition and consumer protection authorities.
Just so that we're clear, do you agree that Fox Television and Perez, line of precedent governs here, in that you are essentially reversing course or changing course from, a prior policy, which you have obviously the right to do, but there's a little bit more of a enhanced explanation that's required, right?
I don't agree that there's an enhanced explanation required, Your Honor, but so I agree FCC v. Fox does apply here, and what FCC v. Fox requires is that we acknowledge that we're changing position and that we provide good reason for it. But it doesn't need to be a better reason, for example, than the prior policy. We just need to show that we believe it to be better, and in fact that we provide a good reason. And so we bring two reasons to this court. One is that we think it makes sense to return to the long-standing Title I framework and classification as a legal matter, since it has been approved by previous bipartisan majorities of the Commission and affirmed by the U.S. Supreme Court. And then independently, we think that we have provided more than enough good reason for reverting as a public policy matter.
You talked about the longstanding background. I mean, it's interesting that both sides have completely different longstanding backgrounds. And my more particularized question is when we talk about, there wasn't much evidence of problems of blocking and throttling or paid prioritization problems. Was anybody doing that? Was however one wants to characterize the time period prior to 2015, is there any basis on which to conclude that ISP providers thought they were at liberty under those prior regimes to block, throttle, or adopt paid prioritization? Or do we just not know?
Well, Your Honor, what I would say is that under the prior regime, under Title I, the only time in which there was a limited amount of time in which there were conduct rules in place. They were heavily challenged throughout that time period. We did have an enforceable transparency rule in place since 2010.
And you had the Internet policy statement in 2005 about user, and it's I guess a policy statement, but the question really I'm just trying to get from you is, did ISP providers, would the Commission have considered them at liberty in this period prior to 2015 to engage in blocking or throttling or to adopt a paid prioritization practice, given the policies and everything else that was just evolving
Yeah, I mean, in terms of what the particular commission would have thought under the four principles or under the 2010 approach, I think that would depend upon the commission, Your Honor. But I think our broader point is that we don't think that the reason that the internet economy flourished during this entire time period was because of the possibility of vague federal oversight of these particular practices. In fact, I mean, one of the prominent examples that's listed in the record, the AT&T FaceTime example from, I believe it was 2012, That was an example where something that a provider was doing that turned out to be unpopular with consumers was quickly corrected once it came to light within 3 months without the possibility of without the necessity for government oversight. And so what the commission did here in 2017, looking back, was to determine that when we weren't seeing evidence of market failure in the record, and we weren't seeing evidence of pervasive harm in the record, that it was permissible for the commission to rely instead and switch
Would it
to
have
a
to be pervasive
transparency.
harm?
I think so, Your Honor, or at least that's reasonable as an economic judgment for the commission. I mean, their theory of the case is that every neighborhood in America is a potential terminating access monopoly. And you would think that over 15 years, if indeed there were these overwhelming incentives for providers to block and throttle content, that you would see much more evidence of that.
If they understood, I mean, that's why I think it's really, I mean, you say you don't know what prior commissions were thinking, but it seems to me central to your argument, your rationale in the order that these incentives don't get acted upon. Look at the history to say that ISP providers would have understood they were at liberty apart from public reaction to do that.
Well, I mean,
or maybe that's evident. I mean, I just don't know what, it's hard to know whether they weren't doing it because they understood there'd be a swift reaction from the commission or a swift reaction from the public or the FTC. I just don't know how we analyze why these actions weren't being undertaken.
Well, I think the ability to make those predictive judgments fall first with the commission, and I make a couple of points in response to what you said, Your Honor. First of all, certainly no one was relying during that entire period upon Title II classification, nor for much of that period where anyone relying upon enforceable conduct rules. And so, I mean, I think it was reasonable for the commission to approach this from that perspective. Moreover, where the commission saw evidence that markets and transparency were capable of resolving these problems, and that these problems, by and large, were resolved very quickly. I mean, even in some of the cases like Comcast, by the time that the regulatory process was unfolding over a long period of time, in the meantime, Comcast changed its network management practices before that process had even completed. And so, what the commission determined here was that we could achieve comparable benefits at lower cost without all of the negative side effects of Title II classification by switching to a transparency-based regime, that there was not the evidence in the record that you would want to see before a federal agency decides to determine ex ante what types of service offerings would be popular with consumers or which ones might be affirmatively harmful, that through transparency, consumers will be able to have additional choice.
What's the regulatory cost of just banning blocking and throttling?
I'm sorry, Your Honor.
What's the regulatory cost of just having a ban on blocking and throttling?
Yes, Your Honor. So first of all, we conclude that we don't have legal authority for those rules after the reclass. Apart from that, what the commission determined was that those rules, even under the 2015 regime, were subject to a reasonable network management exception, and that many of the disputes over blocking and throttling could be characterized as such. The commission also determined that there was a consensus against these activities and that providers were either A, unlikely to engage in them to begin with, or if they did, under a transparency-based approach, there would be fierce consumer backlash. And that's something that was missing from the petitioner's presentation earlier. I do think it's the case, Judge Wilkins, I think Judge Millett, you asked a similar question, that under our transparency-based regime, providers are required to provide prominent disclosures on an easily accessible website. And if it's something as simple as we're blocking Facebook, that's going to be very easy for consumers to see and fierce consumer backlash.
So what does that mean
will ensue.
in practice? What is going on? Because presumably people have had to file these things.
Yes, Your Honor.
So does there have to be, when you say prominent, does that mean there has to be, a click on their homepage that says, see our transparency policy, or when they turn them into the commission, how easily accessible is it for somebody? And then is it just that information, or is it there? And maybe it's in all capital letters, but it's part of a very, very long list of other things.
No, Your Honor, it's its own document, and it needs to be provided. I mean, we did decline to prescribe a particular format for it, for flexibility's sake, but it does need to be prominent and easily accessible. And commission staff.
And its own distinct document?
I believe so, Your Honor. But in any event, it needs to be easily accessible on.
I mean, that's very different. I mean, its own separate document, and easily accessible could just mean I can get to this very long thing that has 16 different other cautions and warnings, and it goes on for 8 pages, and it's single print, and I don't look at it.
Yeah. Well, but what I can tell you, Your Honor, is that the commission is monitoring for that. So the commission just determined in its first report to Congress after this was adopted, a little over a month ago, it determined that there was almost 100% compliance with this rule. It used our internal data to identify service providers, and we checked on their websites. We determined there was almost complete compliance, and we were working with those providers who are non-compliant to come into compliance. And one of the things that we're monitoring for is whether or not there's sufficient clarity in the communication. And this is something where the FCC retains jurisdiction over to determine whether or not communications are sufficient.
You have told them that it has to be its own separate document.
I don't know the answer, but I mean, given that it's a web page, Your Honor, that might be. I don't know that we've said it needs to be a particular URL with nothing else on there. But in any event, Your Honor, it is something that we're policing, and then of course, both us and the FTC have entered into a memorandum of understanding.
But there were some
so that,
providers that weren't up to snuff with their transparency thing without, I'm not asking you to identify those providers, but can you identify did they just not have one, or is there something that was wrong about their display that you said this doesn't count?
I don't know the specifics, Your Honor. What the report says, I mean, I think the compliance was up to like 99% or something very high in the 90s, and that and that staff was working with those, and they were smaller providers that hadn't yet complied with the mandate.
Now, let's suppose there's a major provider that has an agreement with Hulu where Hulu pays them, and so their content will get full speed. And part of the consideration is that the provider will throttle down Netflix content. And that's part of the compensation, and that's the quid pro quo, and that's the arrangement. Under the current rule, that's can be done as long as that's disclosed pursuant to the transparency rule, correct?
Your Honor, under our rules, someone could do that if they fully disclose that's what they're doing. I would say that what we have found is that it's highly unlikely that someone is going to throttle traffic in that manner. And in fact, what we determined with respect to paid prioritization was that to provide a priority lane, it doesn't necessarily, neither do providers have the incentive to throttle best effort service because they have an incentive to keep their platform.
Whether you believe or whether the commission believes it's going to happen or whether it's likely to happen is I understand, I take your point there, but you concede that there's nothing under the new rule that the commission has promulgated to prohibit that activity so long as it's fully disclosed pursuant to your transparency rule, correct?
Correct. Nothing under our rules, Your Honor. Now, there could be other legal consequences. The FTC and antitrust authorities could review any such arrangement under their unfair or deceptive practices authority.
What's deceptive if it's disclosed?
If it's fully disclosed, Your Honor, there wouldn't be anything deceptive. But career staff have submitted comments in the record from the FTC and indicated, among other things, that they retain authority if, for example, there's a unilateral change in policy by a provider that itself could give rise to a potential unfair practices claim. And precisely because these things are so unpopular with respect to discriminatory blocking and throttling, we do have commitments by the major providers not to do this. And it's not merely that we're taking their word for it, as someone said earlier, but that the FTC has told us that those become legally binding promises to consumers.
And what would, I'm sorry.
So I guess the follow-up would be, let's suppose that provider also has a policy where they just disclose from time to time in our discretion, we will throttle down edge provider content. And, you know, at our discretion, we reserve the right to do that, and they have it all very clearly disclosed. That's fine under your rule, right? As long as that's disclosed, they can do that.
I don't think so, Your Honor. And I mean, I don't want to prejudge the outcome of a particular case, but one way in which our disclosure requirements were actually more detailed than the prior approach, of course, because now that we've removed the conduct rules, we require specifically that you identify blocking, throttling, and paid prioritization, including what it is that you're throttling, blocking, and paying to prioritize. So I don't think a general disclaimer that we may from time to time throttle would satisfy our rule.
And how would antitrust law protect against, we are hereby blocking this terrible, violent, pro-Nazi website?
Yes, Your Honor. So, I mean, apart from the ways in which antitrust law could evaluate particular cases as attempted monopolizations and vertical exclusions and the like, the theory underlying the order...
That's not an attempted monopolization.
No, exactly, Your Honor. But that's a backstop on competition-based. But the theory of the order is that if the market is adequately policed by consumer protection and competition authorities, then providers will give consumers what they want, and to the extent that consumers value open platforms. And again, we think that there's significant incentives for broadband providers to provide open platforms. Those will be the offerings in the market. And a number of these questions have sort of focused on what I'll call sort of corner cases that may or may not arise. And again, it's not the case that we have a duty under the APA to resolve that antitrust and consumer protection authorities will resolve every last possible problem. I mean, federal agencies are not required to regulate to the point of guaranteeing that you're reaching.
No, but so someone says they disclose we're going to block, and now we're going to block all. You know, we're going to block. They list the 5 sites because they're very contrary to our announced value. Pick whatever policy value they want to have. We announce it, so it's fully disclosed, nothing monopolistic about it. And the providers that only have one ISP provider are stuck, right?
No, I don't think that providers with only one ISP provider are stuck, Your Honor. So, I mean, we made a couple of findings with respect to competition here, which is the competition here is widespread and it's increasing, and competitive pressure is not placed on the provider merely by the particular locality where conduct might be occurring. These stories
Say that again. You said that the commission made a finding that competition is increasing. What kind of, in what market specifically is it increasing?
So I would...
The wireline, it's increasing?
So 2 responses, Your Honor. I think that chart shows essentially a success story of increasing speeds and increasing deployment. The new standard of broadband, 25 down, 3 up, that we announced in 2015 is already at 2 providers or more at 50% of the market. In addition, Your Honor, we find that there's been increasing intermodal competition in the market. Everyone agrees that the mobile market is competitive, and what we're finding is that 1 in 5 Americans are cutting the cord entirely and relying solely on mobile service.
20%. You said 1 in 5, so 20%.
1 in 5, Your Honor, and it actually goes across all different demographic groups. And so, you know, in terms of salary, and so. What the commission...
That sounds like that increase and expansion happened while the 2015 order was in effect?
Your Honor, certainly our claim is not that no deployment occurred while the 2015 order was in effect. It is simply that we have made a judgment that the rules that we are putting in place are better incentivizing deployment. But the point for present purposes is that these are real competitive pressures that are being placed on broadband providers, and it's increasing. With the advent of 5G, we expect even faster speeds and more deployment on the wireless side. And at the end of the day, Your Honor, what we're doing here is we are creating rules that are built to last. And what we're finding is that this market is evolving and dynamic.
And is
it's
it built?
not the top?
I think this is part of your reporting duties. Is there in this record findings that increased competition, increased availability of even higher speed internet is including the areas that are sort of the technology deserts, the places where there's limited or there's only one provider or only two, but two slow providers? Or is this increase happening mainly in the areas where there's already, the urban areas where there's already more competition and more customers to incentivize the expansions?
Well, Your Honor, I think in terms of fixed, we have the chart that shows it by census block, and I think our response is there is that there are significant competitive constraints imposed both by spillover effects and intermodal competition. And then again, Your Honor, with respect to the underserved areas, the question then becomes, in the Commission's judgment, what is the best way to promote broadband deployment in those areas? And we found that Title II was having a deleterious effect in that regard.
So deployment went down in underserved areas under the 2015 order. That's in the record?
I'm sorry, Your Honor, I missed the first part of that.
Deployment of capabilities went down in sort of underserved areas under the 2015 order. Is that what I heard you just say?
There's the evidence of that appears in paragraph 104 and also note 391 of the order. It's significant.
What page are you on?
I'm sorry.
Make it faster for me.
It's paragraph 104 and note 391, which was we get into the evidence in which the chilling effects of Title II were preventing small providers without sufficient resources to analyze the potential regulatory costs of deploying in these underserved areas. One provider saying it was going to do a multi-county fixed wireless service, and it determined it was no longer going to do that. And these reports, Your Honor, are.
Sorry, is it only the small providers that go into underserved areas?
I mean, it depends, Your Honor, but a lot of small out-of-the-way places are served by small wireless providers called WISPs, and sometimes it's the only option. And this is generally confirmatory of our economic theory that the overhang of these types of regulations tend to deter deployment, innovation, and investment. So if I could, I'd like to move on to questions concerning the authority of the transparency rule, because I know there have been some questions about that today. The first point I would make about that, Your Honor, is that, as we say in our brief, the petitioners lack standing to challenge this. Everyone at our table agrees on two things. First, that transparency is a good idea, it's good policy. No one on the other side of the table is actually injured by our transparency rule. And in addition, everyone agrees that we have authority. We assert authority under 257 of the Act. If everything that the petitioners say is true, they would admit under Verizon that we would have authority under 706. So this is ultimately an academic debate about legal.
But do you agree that you have power under 706?
We do not agree with that, Your Honor. But,
That's not so
the
academic.
question is a remedy that this court could fashion, because even they agree under their view of the world.
Well, we couldn't say you
for
have
the commission.
power. We couldn't say you have authority under 706 if you haven't claimed it, could we?
No, Your Honor, but in that case, then what you would have, and this gets to another point made about how transparency relates to the rest of the order, we have reclassified broadband based upon our legal and public policy analysis. Once we're there, We don't have authority for the conduct rules. What we know under Verizon and US Telecom is that we can't enact the per se conduct rules even under 706. So their whole theory of why they can challenge transparency is that somehow it gets them back to conduct rules, and it doesn't. There's no way you can do it. All it would get you to is to a world in which we were doing transparency under some other provision of the Act. But in any event, Your Honor, we think that we have ample authority for transparency.
So you're saying that transparency is not linked to the rest in the way that petitioners argue, because in the event of vacating the current order, the commission would be completely free to proceed under, well, either to fill the intellectual Chenery gaps that are asserted, or to invoke Section 706.
That's correct, Your Honor. That's correct, Your Honor. It's separate from the reasoning in the remainder of the order. We do think that we have authority under 257. I mean, the court suggested that in the Comcast case itself, that 257 coupled with ancillary authority could serve as a basis for a transparency rule. The mention of regulated parties there is of no moment, apart from the anachronism Judge Williams mentioned. It's simply not the case that Title I providers are not regulated entities. We've simply made a different classification decision, and that carries with it different substantive regulatory consequences, but that doesn't mean that we can't impose disclosure requirements where we otherwise would have authority.
I'm curious
And
why, or do you agree that maybe, do you read the NPRM as not identifying 257 as a source of authority? Or do you read it as having identified it? Or is it just that it doesn't matter because other people identified it?
Yes, Your Honor. I think it doesn't matter. I think the NPRM is clear enough when we say that we are seeking comment on any sources of authority, including the authority that's cited in the Open Internet Order. And the reason, Your Honor, for the specific deletion of that paragraph is that the body of that paragraph referred to Section 4K of the Communications Act, which had been repealed, and so that is what we're specifically trying to take off the table. But it defies logic that parties would not understand, given the history of this case, the fact that 257 is cited as a transparency rule in Comcast, was relied upon in 2010. Judge Silberman also picked up on it in his partial concurrence in Verizon, and several parties, as petitioners noted, actually cited a 257 in their comments. I think it's fairly included in the order, or at least is a logical outgrowth and is harmless error given the history of this case and the comments that were actually made.
And so I just haven't, and maybe explain, I haven't seen a case where an agency relies on a statutory provision as a source of authority, and then that source of authority gets repealed, or at least in potentially a quite relevant part, just before the order issues. And it's not quite sure, one, have you ever seen it? And two, how are we supposed to deal with that?
Yes, Your Honor. So two responses to that. First of all, we don't consider what happened here to be a repeal of this provision. This provision was recodified in a different part of the Act. 257C was repealed, but 257A remains on the books. And there was a savings clause in the new Act that basically said this was not meant to alter pre-existing commission authority. And so the commission would have the same ability to rely upon the language in 257A relating to its authority to identify potential market barriers to entry under the new statute. And the other thing I would say is that in the recent broadband report that we were just discussing, Your Honor, with respect to the collection of information, the commission also cites to the new recodified requirement. So we're not here acting under the suspicion that perhaps the commission thinks it's no longer permitted to collect these reports or analyze them, or that it now has to do something different.
I understand the argument. It's just trying to figure out under Chenery, it seems, whether since they just recodified and they said it's not meant to affect your authority, does that just mean in this unusual instance it's just not a Chenery issue, it rides along in its new form, or should we just look at 257A?
Well, I think you could do both, Your Honor. I mean, this is basically this was a consolidation and a switch from a triennial to a biennial report. It still requires us to assess the same things that the pre-existing statute required us to assess, and it doesn't remove the language in 257A that the reports were previously key to, there is this relationship between A and C that the petitioners ignore, which is that what the report to Congress is supposed to include is an indication of the market barriers that we've identified, and then the steps that we've taken to eliminate either through substantive regulation or through recommendations to Congress for legislative change.
As your time is getting down here, I was hoping you could explain to me how paid prioritization works, and then after that, what the impact would be if someone were to adopt it on public safety communications. But I don't know whether that means everyone says you're in the fast lane. Well, is that a different cable, or is it an ordering thing? They move first, they jump the line. I just don't have any sense of how it works, so it's hard to even understand what the impact could be, or not.
Yes, Your Honor. So I think the key discussion here is paragraph 258 of the order, in which we make basically two findings with respect to paid prioritization generally. The first is that we reject the idea that paid prioritization in prioritizing certain packets for delivery would affect best effort service. We think that certainly providers don't have the incentive to do that independently on their own accord, and that there are network management practices that can continue best effort services even if particular packets are prioritized. And the second thing we find, Your Honor, and this is also directly relevant to the public safety issue, is that a quality of service arrangements will actually help benefit small providers, niche providers, the type of providers that that public safety officials might want to utilize by giving them the ability to have these sort of dedicated networks. Now,
That's in the order too, that it'll have this impact on public safety, those who need public safety because of how it'll affect niche providers?
No, so Your Honor, our basic response there is that the types of concerns that those petitioners are bringing to you are the same concerns in type that other edge providers and consumers are making in the record. So in the footnotes that we discuss at paragraph 258, we talk about, for example, how telemedicine might be one area in which latency-sensitive applications could benefit from paid prioritization. We reject notions, for example, that U.S. national security would be hurt by a paid prioritization scheme, because again, we actually think that providing more consumer choice, more options for quality of service could actually benefit particular functionalities like that. And we talk about, and we say the same thing with respect to nonprofits. And so there's really nothing
Their
unique.
argument is whether you think our complaints sound like others, the remedies that you invoked don't work for us, right? We can't. If we are slowed down in delivery, it's no good for us to go afterwards to the FTC and try to say there was some fraud or we weren't warned, especially if it was disclosed. It's not an antitrust issue. So post hoc remedies don't work in the public safety context. And that, unless I missed it, was not addressed anywhere in the order.
Well, Your Honor, I think that the burden ought to be on them to show concrete evidence of harm. And you
Why is the
asked
burden
that,
on
and that
them?
was
The
not-
statute repeats again and again that public safety is an important goal here. You had comments expressing concerns, a lot of them. It seems like you had a statutory obligation, you had a lot of comments, a serious issue that should have been addressed by the commission in the order. That's not a burden on them.
Well, but Your Honor, the response should be commensurate to the types of claims that they were making, and they might have a case if they could point to concrete harms. The only actual evidence.
Why do they need a
of harm
case
that
when
they-
people weren't doing this or weren't able to do this before? At least it's a paid prioritization.
Well, Your Honor, I think you asked them back in the Title I era whether there was any evidence that there were harms related to blocking and throttling or paid prioritization. And I heard that they couldn't point to anything concrete. What I take their point to be
They've pointed to
is that
things. They've pointed to things, and it's in the briefing, and I'm not going to spend our time rehearsing it now. They identified concerns, and they've explained how these post hoc remedies don't work for them. And I don't does the commission think the post hoc remedies work for them?
Well, Your Honor, I mean, two responses to that. I mean, first is that an underlying premise of this order is that, networks and services and innovative services don't actually have to be built. We think that we are putting a framework in place that will actually benefit edge providers and end users by incentivizing new services. And the second point I would
Right,
make, Your Honor, and
incentivizing new services like the paid prioritization.
correct, Your Honor.
Okay, but
quality of service agreements.
if local governments can't afford to pay for that for their firefighters and ambulances and other emergency services and disease control announcements, how does this help them?
Well, Your Honor, two responses to that. First, I don't think it's true that they can't afford it. A lot of states and municipalities rely upon enterprise services. Remember, this order deals with mass market retail service, and so there are other tools such as enterprise services. The other thing, Your Honor, and this came up in the questioning before, is that there are dedicated communication pathways that deal with emergency alerts. EAS is one. There's one for broadcast, and there's the FirstNet system and other systems that are available that are outside of this order. And we have a public enforcement, a public safety bureau that administers all of these. And so it's not the case that, this order is about mass market retail service, and then the question then is whether we have discretion.
So
to
this
put
order
rules in
doesn't
place.
apply? I'm sorry, I don't even understand that answer.
Well, it would apply to the extent that they're purchasing mass market retail, Your
Yeah.
Honor. And so to that extent, we determined both that prioritization would not prevent best effort service from operating, and secondly, that we think that quality of service arrangements will both incentivize new edge providers to enter the market as well as incentivize an increased broadband capacity, and that benefits everybody.
All right, so back where I started, just technologically, how does paid prioritization work? Does it mean somebody jumps the line? They get their stuff sent through first, faster, there's an ordering and how things are transmitted. There's got to be, if they're going to charge people for it, they've got to be able to explain to them what it is that they're getting. Do they get, is it like the toll, high occupancy toll lanes, you get your own lane? That seems unlikely to me, but I don't know the technology. I'm not going to have a special cable just for that. So to let something else go faster, don't you have to either stop or slow down other things?
Yeah, the packets are prioritized, and they would be delivered to the end user on an expedited basis. And
So
their
that means
network
what's not
management-
prioritized could be going a delay that it doesn't currently have.
Yes, but then, Your Honor, there'd be network management tools that you could deal with that. So, for example, if congestion would otherwise result, there would be for latency for applications that don't require a lot of latency sensitivity, such as you're getting an email 10 milliseconds late or something like that. That is the traffic that would then be deprioritized in a way to make the service work. And
I guess I'm trying to figure out
again,
how
this
this
is the
helps them
sort
if
of
they're
a-
trying to share photos as fast as they can as they're chasing a fleeing fugitive, or they're trying to identify someone who's threatened to harm a lot of people, or they're trying to deal with wildfires or get a disease under control. I don't understand. They may need not just words. They may need images. They may need videos. They may need things that require a lot of the bandwidth that you're going to have from this, but they aren't going to get to go first. They're going to have to go to the end of the line.
But, Your Honor, we respectfully disagree that there's
Okay.
any evidence that that's occurring.
Well, no evidence because they haven't done it yet. I'm trying to figure out where the commission said that won't happen, or it's okay if that happens. As to public safety, it won't happen, or it's okay if it happens.
What we're saying, Your Honor, is that we think what will provide the best service for all users is the approach that we're adopting today. And that we can't anticipate all harms, especially or resolve all harms with this particular order,
But help me
especially when they have
understand,
not
help me
identified.
understand something here. So you've concluded that you can't impose common carrier regulation, right? The common carrier regulation requires basically that you treat everybody the same. So why couldn't you, to protect public safety, say, we're going to have special rules when it comes to, first responders or certain categories where public safety is at issue, and there's no throttling, or no blocking, or, whatever is required to protect public safety. You have the authority to issue those sort of rules because they wouldn't be considered common carrier regulations, would they?
I don't know, Your Honor. I mean, with the upshot of Verizon and U.S. Telecom is that, per se rules of that type that dictate terms of service could be considered common carriage. And again, Your Honor, the commission put the policy mix in place here with respect to this
What if
particular
you just had a rule that
service.
says, fine, you can do paid prioritization, but you can't prioritize over public safety? That's really, you'd have to have common carrier status for that? You're not disavowing that you would have the authority just to qualify paid prioritization in that way, are you?
Your Honor, again, I think there would be a significant legal cloud over anything like that. What the commission determined here was that, again, it preferred a transparency-based approach to the
Well, it didn't
conduct.
consider that option
And it
because
has-
it didn't address public safety.
Again, Your Honor, we think that we adequately address public safety.
Specifically, right, I get your argument that it was encompassed within everything.
I thought your anticipation was that the permission of paid prioritization would allow essentially entrepreneurs who had some special thing, you used the word niche, that actually required extra speed or extra low latency and so forth, or do you want latency high? I've forgotten. Anyway, extra quality, but that the likelihood of these being inconsistent with essentially good network performance was remote. I thought you said that
Yes, Your Honor.
as we went into this issue.
Yes, Your Honor. I mean,
Yeah.
that is a specific finding that the commission made. I see I'm over time, so I'd like to address the preemption issues if I can. So, Your Honor, what the state petitioners are asking for here is unprecedented. They are challenging the commission's authority to regulate interstate communications. This is not a case in which the states have identified some severable intrastate component or network that they are looking to regulate. Everyone agrees that internet service and or broadband service, and this is consistent with this court's findings in Verizon, is a jurisdictionally interstate service. So as the Supreme Court said in the Louisiana Power case, there's essentially a division of labor within the Communications Act. Interstate services are trusted to the commission to regulate, whereas intrastate services are reserved to the states, and that you can't have two different regulators with their hands on the same wheel. And so what the commission determined here was that the classification decisions that it made, which, as Judge Williams pointed out, is under our lawful authority to classify services, carries with it substantive regulatory consequences. It's not an abandonment of the field. It's classification of an information service under Title I, which carries with it immunity from common carriage, immunity from the types of requirements that would be imposed on a telecommunications carrier under Title II. And so what the commission determined here is that for a state to impose the exact same rules or more onerous rules, as well, or to impose the types of common carriage requirements that would be imposed on telecommunications carriers under Title II, that would undermine the federal scheme, particularly since broadband networks are built out on a regional and nationwide basis. It would subject the providers to the same type of heavy-handed utility-style regulation that the commission declined to adopt in its order. And this fits neatly within the impossibility exception framework.
So what if, pick a locality, New York State passed a regulation that just said that firefighters in New York State, broadband providers can't, throttle services to them, and we define, New York firefighters. What's wrong with that as far as impeding the authority of the commission?
Yeah, Your Honor, so, I mean, in that case, we do say that, traditional public safety functions of the states are reserved, and so I think, it would depend on the facts of that particular case, but I don't know that if it was limited in that way, I think it would
Well, I
present
just gave,
potentially
yeah, I
unique
gave you the facts.
circumstance, but.
So how is that conflicting with the mission of the commission, a regulation like that?
Well, I'm saying a targeted public safety regulation, Your Honor. I don't think that is something that was the core of what we were attempting to reach
But
here.
your order would seem to prohibit that, right? Because your order is written very broadly. Doesn't it say that basically all state and local regulations with respect to broadband are preempted or something of that nature? What we say is economic or utility style regulation, Your Honor. And so what that means, and the examples we give, are the generally applicable conduct rules that were set forth in the 2015 order, the very same rules that we repealed, as well as rules that would impose more onerous requirements, such as rules that went above and beyond the vague internet conduct standard in terms of what could be or could be not provided in terms of data plans, for example. And then we list specific Title II requirements that are common carriage requirements, like unbundling and line sharing and the like. And so that is the core of what we
Go on to say that traditional state police laws that would interfere with federal regulatory objectives. And it seems to me Judge Wilkins' hypothetical seems to fall within that, given the explanation you've given for why we don't need to have any special treatment for public safety.
Well, Your Honor, again, what we're asserting here is the authority to preempt, and so we note, and I think it's certainly true, that to the extent that state rules either stand as an obstacle to or conflict with federal law, whether that be statutory law or this order, that there would be preemption. We're not trying to exhaust the universe of things that might be preempted in a particular case. The theory behind their petition is that we simply don't have authority.
I had read this as a declaration of preemption. Are you saying instead that this is just a heads up that ordinary conflict preemption principles are going to apply, or is it broader than ordinary conflict preemption?
No, Your Honor, it's express preemption, but my point is that
It's
whether
broader than ordinary conflict preemption.
That's correct, Your Honor, but when you're interpreting the part of that language that says stand as an obstacle to, whether a particular law would
Not
in
obstacle,
fact-
it's interfere with federal or regulatory objectives. That's not the same thing as stand as an obstacle to a legal requirement.
Yes, Your Honor, and I think it would be available to the commission in a given case to make that argument under any number of standard preemption theories, whether that be obstacle preemption, impossibility preemption, conflict preemption. I mean, the core of what we're expressly preempting are, I'm sorry, Judge Wilkins.
Well, the language here that the commission used is, we therefore preempt any state or local measures that would effectively impose rules or requirements that we have repealed or decided to refrain from imposing in this order, or that would impose more stringent requirements for any aspect of broadband service that we address in this order. That's pretty broad. And then it
That's
says,
correct,
among
Your
other
Honor, and I
things,
think-
we thereby preempt any so-called economic or public utility type regulations.
That's correct, Your Honor, and so I think that under the impossibility exception, what we need to do is, one, identify that it's an interstate service, that we're acting pursuant to lawful authority, and then to relate it to a federal objective. And the federal objective that we're relating it to includes both the fact that both the fact that an information service under Title I, as well as a private mobile service under 332 are immune from common carriage requirements and shall not be treated as telecommunications carriers. That plus the fact that we replace that regime with a light touch transparency regime represents a federal policy of subjecting these entities to a light touch regulation and sparing them this utility-based regulation. It would undermine the scheme if a state was to step in and impose requirements that were inconsistent with the findings that we make in the order.
You say you're acting pursuant to lawful authority, and what's the statutory authority?
Yeah, I think primarily, Your Honor, it's the two classification provisions of the Act. We have the authority to classify services, and they carry with it substantive regulatory consequences determined by Congress.
So the definitional provisions.
What's that,
The
Your Honor?
definitional provisions in Title I are your source of preemptive authority.
Yes, Your Honor, that plus, coupled with the jurisdictional provisions in the statute, which give us authority to regulate interstate services. I realize I didn't get to touch on mobile, if I could just say a few words about that. Your Honor, it was eminently reasonable for the Commission to return to its prior understanding of mobile broadband service as a private mobile service under Section 332 of the Act. Unlike other parts of the Act, this provision gives explicit definitional authority to the Commission to define terms, and the two key terms in the statute are interconnected with the public switch network. And the Commission determined that the public switch network ought to be defined in the way that it had traditionally been defined as the public switched telephone network, and that interconnection requires that the service itself be interconnected with the network and therefore capable of reaching all end users on the North American numbering plan. Now, I think the principal argument that the petitioners are making here is that it was somehow arbitrary for the Commission to focus on the characteristics of mobile broadband or mobile voice itself, as opposed to considering the possible functionality of add-on applications like VoIP. But what the Commission determined is that it is the service itself that must be interconnected with the telephone network. So it's not relevant whether we're talking about particular hardware or software provided by a manufacturer or particular applications that are downloaded off the internet. The question is whether the service itself is providing the interconnection. Mobile voice is a service that actually is capable of pinging the cell tower to interconnect with the PSTN, whereas these add-on applications are not. And finally, Your Honor, because there is this explicit definitional authority, it was reasonable for the Commission to conclude that given its regulatory classification decision on broadband, that it could define these terms in such a way as to create parity between the classification of broadband generally and the classification of mobile broadband, which otherwise, if it were a commercial mobile service, would be subject to common carriage.
All right, thank you very much.
Okay, thank you.
Mr. Nectarline, you've been waiting very patiently. Thank you.
May it please the Court. John Nectarline for the ISP Associations.
I hope you brought pizza.
I know I have 15 minutes. There are about 4 or 5 topics that I want to get to quickly. I'm going to try to do it as efficiently as I can. With respect to classification, I think I'd first like to read from a passage in U.S. Telecom itself. Now, a lot of the arguments that we've heard from the other side today are Chevron Step 1 arguments and Chevron Step 2 garb. And here's what Full Service Network argued in U.S. Telecom. According to the court, Full Service Network urges to resolve this case at Chevron Step 1 on the ground that broadband is unambiguously a telecommunications service because it functions primarily as a transmission service. That argument clearly fails in light of Brand X, which held that classification of broadband as an information service was permissible. That was the panel decision. Then, on rehearing en banc, after the FCC had already issued its draft NPRM, proposing to reclassify to Title I, The two judges in the U.S. Telecom majority said in their separate concurrence, the Brand X court made clear that the act left the matter to the agency's discretion. In other words, the FCC could elect to treat broadband ISPs as common carriers, but the agency did not have to do so. So this is a classic Chevron Step 2 case, and it ultimately then turns on policy issues of the sort that the Commission articulated in its order.
No, but the thing is here, the Commission relied on a different word. We're working with the word capability here, and so that doesn't get to the point of whether they could have done it invoking other authority. And put aside the DNS caching. Just if all we had was capability here, then we'd have a different issue, right?
I think you can't put aside DNS and caching because the combination of internet access with DNS caching is the only possible way to explain the passage in Brand X that someone referred to earlier. This was in response to an argument in Brand X when a consumer goes beyond walled garden offerings and accesses content provided by parties other than the cable company, the consumer uses, quote, pure transmission, no less than a consumer who purchases phone service together with voicemail. That was an argument made in Brand X. It sounds very much like the argument the petitioners are making here. The court explicitly rejected that argument on grounds that are equally applicable here. Court
That wasn't as to interpreting the word capability, was it?
Sure. So
It was? Sorry, I'm not sure you're sure meant.
it was either adopting the FCC's primary theory here or its alternative DNS and caching theory. There's no possible way to construe that passage in Brand X without concluding that the Commission has discretion to rely on one or the other of those theories or both in order to get there. And I want to talk about the capability questions that you asked, Judge Millett, because, in fact, this is just the plain meaning of the definition of information service. The question, when asking
Chevron
whether—
Step 1 argument right now when you say plain meaning?
I'm sorry?
Are you making a Chevron Step 1 argument right now with plain meaning?
Some of my clients, in fact, have preserved a Chevron Step 1 argument.
That's
We
what you're
don't
making
think we
right now.
need to get there in order to defend the Commission's reasonable discretion here. But at a minimum, the definition of information service is at least consistent with the FCC's reasonable interpretation here. There is no question that what any ISP does, whether it's a dial-up ISP, a non-facilities-based ISP, or a broadband-based ISP, as in Brand X, is offer a capability for generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information via telecommunications. That is the definition of the service. And remember in Brand X, that Brand X was not a net neutrality case. It was a case in which ISPs who considered themselves to be Title I information service providers wanted an input from cable companies that were also competing with them in the provision of broadband internet access. Everybody agreed in that case that an ISP, a provider of internet access, is a Title I information service provider. What the Brand X challengers wanted was the transmission capability between the customer and the computers linking the ISP to the rest of the internet. Now, that pipe itself doesn't get you access to the internet. The provision of that pipe is itself, by itself, without internet access, just a Title II telecommunications service. It is the combination of that pipe with internet access, which everyone agreed in Brand X was a Title I information service, that makes the retail broadband internet access offering an information service. And in Brand X, the only question was, is this just an information service, or is it an information service plus a separate pipe connecting the customer to the computers of the ISP? That was the only issue in Brand X. It was common ground that what any ISP offered, whether it was a non-facilities-based ISP or a cable modem provider, what they offered is a Title I information service. And this is also consistent with MFJ precedent. Judge Williams, you asked about Harold Green's definitions. At 673 F. Sup. 587, Judge Green describes two categories of information services. They are both prohibited to the Bell companies unless they obtain a waiver. The first category is what petitioners say occupies the universe of information services. That's the provision of information content. But the second category was also considered an information service. He was explicit, and I'm quoting, operation of the infrastructure necessary for the transmission of information services generated by others. And there was some dispute in the record about whether the term information service really went that far to include the capability of accessing information services provided by third parties. And Judge Green said, yes, it does go that far, and you do need waivers in order to provide these things, quote, in view of the breadth of the information services definition. So I mean, the FCC's interpretation here is entirely consistent with that precedent. And again, the definition of information service comes explicitly and verbatim from the MFJ language itself. It is a much more direct descendant of that language than it is of the computer inquiries regime. But the same outcome arises under the computer inquiries regime as well, as the Commission has explained in describing the Stevens report.
Do you
Now,
have
of
a
course,
position?
go ahead.
Sorry. Do you have a position on what courts are supposed to do with the discussion in Brand X of what a consumer understands they're being offered?
Sure. In Brand X, the sole question, again, was, does a consumer perceive that he's getting only an information service, or does the consumer perceive that he's getting that information service plus a segregable telecommunication service in the form of transmission between the customer and the ISP's computers? And the court said that consumer perception is relevant to that one service or two service issue. Again, our opponents in this case are not arguing that there are two services here. They agree there are two services. What they reject is the common understanding in Brand X that there is, at a minimum, an information service here.
Common understanding of consumers? Is this just a reasonable, I just don't even know what to do with that test. What would a reasonable consumer understand as opposed to a polling of consumers?
Sure, and the question is, does a consumer perceive that the thing, does a reasonable consumer perceive that the thing that the reasonable consumer is receiving comports with the definition of information service? And that is what a reasonable consumer would conclude. And the FCC also did a consumer survey and concluded the same thing. But you don't even need to conduct a consumer survey to agree that any consumer, when he or she orders an ISP service, is ordering the offering of a capability for generating, acquiring, storing, et cetera, making available information. So at a minimum, this is, again, a Chevron Step 2 case, and it turns on policy judgments. So the question before the Commission was whether to stick with a common carrier regime that the Commission concluded had, and I'm quoting here, had not lived up to its light touch billing. The Commission identified a variety of distortions that were in the market that were caused by imposing common carrier regulation on this industry. And it concluded that there was not sufficient evidence of an empirical concern about internet openness to justify that regime. In fact, there's really not a track record of ISP misconduct at all in the last 12 years. And that is that lack of misconduct, in response to one of your questions, Judge Millett, occurred during a long period in which, frankly, there were no rules in effect. I mean, if we go back to 2005, there were no rules in effect.
Well, I'm not sure. I get that everybody has their different vision of what that time was, and they're diametrically opposed. It seems to me it was a very evolutionary time, and there were policies and announcements and maybe understandings. And as the technology was rapidly developing and expanding, folks were sort of waiting to see what the Commission was going to do, and they were dipping their foot in different things, which might not be the optimal time for an ISP provider to go, let's go throttle some people.
Well, it's actually quite striking that over this long period of time, there really were no incidents. And I mean, the commission conducted what it called a controlled experiment when it saw there were various points at which this court vacated any substantive net neutrality rules. And as it observed, there was no epidemic or even uptick of bad acts during that period. In fact, there were no bad acts. Now, we can disagree with our opponents about what a bad act is, but in terms of blocking or throttling of the sort designed to disadvantage disfavored conduct, no ISP wants to engage in that. And that's why it is so easy for ISPs to put in their terms of service a guarantee to consumers that they won't engage in that. And if I could just pause briefly on questions about disclosure. This is probably the most scrutinized industry in America. The disclosures are not just for consumers. They're also for public interest organizations represented here by petitioners and the interveners. And whenever there's any deviation from longstanding norms in traffic management or terms of service for users, it is immediately placed under a microscope. So there's no way that any ISP could get away with an inconspicuous disclosure. And in any event, the Commission's rules prohibit inconspicuous disclosures. They require quite conspicuous ones. And
What does that mean? Can you just tell me how they're doing it? Is it a distinct piece of, not piece of paper, distinct link on the website, however it's,
my
its own
understanding,
link, its own tab, its own separate document?
well, some ISPs, in fact, have taken out full-page newspaper ads trumpeting the fact that they have no interest in engaging any net neutrality violations.
That's probably public relations. I'm assuming that's not what you can, that's not what satisfies a transparency rule.
That is correct, that you have to put it on your website. My understanding is that as a matter of general practice, there's a page where the ISPs describe their network management practices, and they commit not to engage in blocking or throttling.
Is there a whole bunch of stuff on there? Or does it just say no blocking, no throttling, no paid prioritization?
The Commission's rules actually require more detail than that, but at a minimum, they require the ISP to disclose whether they are engaging in blocking or throttling or paid prioritization. And here's a reality that also I think gets lost, and there have been a lot of colloquies today about paid prioritization. So paid prioritization on the public internet doesn't exist today, to my knowledge. It has never existed. There are various prioritized services, but they all fall within specific exemptions under any administration's net neutrality regime. So, for example, public safety officials routinely buy what are called enterprise services, which come with QoS guarantees. A lot of other large businesses order these. Those communications are managed on net, and prioritization is accorded to certain types of signals like voice over email transfers, for example. But that's all permissible. This is routine in enterprise services. Paid prioritization is a theoretical construct in which multiple ISPs would agree that they would impose priority markings on packets to signal to other ISPs that certain handling should apply to those packets. To my knowledge, there is on the public internet no such arrangement. And so all of the speculative concern that we've heard about winding dirt roads or fast lanes and slow lanes is entirely speculative. And what the Commission reasonably concluded here is that fear of abstract theoretical concerns of speculative harms at some point in the future cannot outweigh the demonstrated impairment of investment and innovation.
ISP providers submit comments saying that they wanted to be able to do paid prioritization as part of this rule? They want to have that option.
I think that, so I wrote one set of comments, and you can find it in Volume 1 of the Joint Appendix, and we observed, this is for AT&T, we observed that there is not currently today such a thing as paid prioritization over the public internet. And we said it is nonetheless bad policy to impose a blanket prohibition on paid prioritization because you can imagine a variety of pro-consumer uses of paid prioritization. I think Judge Williams identified a few of those in his dissent in U.S. Telecom. So for example, video
It
conferencing.
sounds to me like they want to be able to have this option, this flexibility.
I think that, that.
People can fight about what the this is, but they
We
want to
don't
be
know
able to-
where the internet is going, and having any sort of flat prohibition on a new technology is not justified in the absence of some rather strong empirical showing of harm. Frankly, what concerned the industry more than the flat ban on paid prioritization was the 8-factor internet conduct standard, which prohibited a variety of pro-competitive, pro-consumer offerings such as sponsored data, zero rating, T-Mobile.
Right, so it would have been easy enough to submit comments saying, get rid of that rule, but we're fine with a rule that says no blocking, no throttling, and no paid prioritization, and we'll let you know if things change.
Well, so I am here representing a large coalition of ISPs, and in fact, some ISPs did say that. Some ISPs said, look, it sleeves off our vest if you want to impose a targeted no blocking, no throttling rule under Section 706. We think the Verizon court may have left you the discretion to impose such a rule. Now, the reason we're okay with such a rule is not because we think it's necessary. We don't think it's necessary because we don't think any ISP gets any business advantage from sabotaging its platform and incurring a lot of political and bad public opinion. The reason why we are okay with that narrow 706 solution is because in the interest of compromise, we just want to put this behind us. Now, not every ISP agreed with that. Some ISPs, I think, reasonably concluded as well that any prohibition, any regulatory prohibition is subject to regulatory creep. So even what might look like a narrow ban on blocking and throttling can be misused by pro-regulatory advocates to achieve what we consider to be anti-competitive outcomes. So here's an example. I think all major mobile ISPs today offer different tiers of service, unlimited plans. Some of them are a little bit cheaper because they give you DVD quality for your video. Some of them are a little more expensive because some people would like to have HD quality video on their devices, even though it's very hard to tell the difference. Now, a number of public interest organizations have recently claimed that that is a violation of net neutrality rules, a violation of anti-throttling rules, on the theory not that it harms consumers to give them greater choice, to pay less for a service that they might value just as much, but instead because there's something offensive about this abstract threat to neutrality, about singling out video as opposed to other applications. That's the threat of any unnecessary rule that, particularly in a fast-moving, dynamic industrial environment like this one, any such rule can be misused to try to prohibit business conduct that in fact is pro-competitive and pro-consumer. Now, we can also disagree about the merits of such plans. I'm quite comfortable in saying that I'm glad, as a subscriber to the less expensive DVD quality service, that I have the choice that my carrier provides for me. The Commission reasonably concluded that this market is better off with that sort of experimentation than it would be in a regime that's governed by disputes about abstract principles of neutrality rather than accepted principles of consumer welfare.
Do you have anything else?
I do have a couple
Will you
things.
wrap up?
Do I have time?
Huh? We'll give you 2 minutes to wrap up.
Okay, thank you. With respect to a couple of questions, Judge Wilkins, your question about the ISP agreement with Hulu to disadvantage Netflix, in addition to the remedies that FCC counsel identified, that would actually also be subject to scrutiny under Section 1 of the Sherman Act as a vertical restraint. It would be subject to rule of reason analysis. The reality is that no one would ever actually engage in that conduct in the first place because consumers would revolt en masse once they discovered that their Netflix wasn't streaming properly as a result of that conduct. Section 257, I agree with Mr. Johnson that there's something highly academic about this dispute. Everybody here agrees that the Commission has authority to impose disclosure obligations, even if the other side were correct in its view of Section 257. At most, the remedy would be a narrow remand to the Commission to reconsider imposing a narrow disclosure requirement under Section 706. It wouldn't, the remedy would not be to throw into question the Commission's fundamental reclassification decision. And finally, with respect to the Title III issues, again, the focus is appropriately on the service that the Commission, the service that an ISP or a voice provider offers. So the focus is not on that service plus device or software, et cetera. It's on the service. So if the service itself doesn't allow you to interconnect, and you need to get a second service in order to interconnect with either the phone network or the internet, then it's not the same service. Just as a voice provider doesn't become, just as a regular data provider doesn't become a voice provider simply because I, as a consumer, can download a Skype app onto my phone. The provider also doesn't become a video provider just because I can download the Netflix app onto my phone. The question is ultimately just the individual service being offered.
All right, thank you very much.
Thank you.
All right, I don't believe anyone had rebuttal time left. Is that right? They went through their time. Okay. All right, everyone went through their time, but I want to give people rebuttal, but I also know everyone's been waiting here a very long time. And so I'm going to ask you to really, Mr. Nicolopoulos, hold yourself, and I'll give you 3 minutes.
All right. Thank you, Your Honor. You are correct. I take your position that capability could be viewed as ambiguous. There could be an infinite chain of links, each of which enables the other. So I think it is key to look at via telecom in the information service definition. And whatever else capability means, it cannot mean any capabilities that the telecom via which the capability is offered is provided. And so we may not be in Chevron Step 1, but I think this is what the court was getting to in the USTA decision when it rejected the USTA argument. It is unreasonable under Chevron Step 2, and we have pled both, to essentially write telecommunications out of the statute. The FCC now acknowledges, Mr. Johnson did, that the service does not include any further processing other than DNS and caching, the proposal B. So that means all there is transmission. All that there is packets moving from one point specified by the user to the other. And again, what Brand X was looking at, paragraph 38 of the cable modem ruling, was those add-on functions only, email, news groups, maintenance of a web presence. All those have gone away.
That just belies the language of Brand X.
Yeah, the language.
The user going beyond the walled garden is using the computer processing functionality equally with the one who's just going to the walled garden.
Yeah, but the relevant quote there, Judge Williams, is information service provided by the cable company. And as Judge Mr. Nucterline also acknowledged, at least one of the theories is that it was referring to DNS and caching, and that's what it was referring to. It went on to talk about DNS and caching. So whether we are in Chevron Step 1 or whether we are in Chevron Step 2, it doesn't matter. It's unreasonable to write telecommunications out of the law. The stab in the heart that I referred to is equally pernicious, whether it's brutal or just unreasonable. And to move to, I'll make only one other point.
15 seconds.
Yes, on paid privatization. The idea that it doesn't exist is a fantasy. Paid privatization happens in many forms. What the New York Attorney General found, that the ISP providers were letting ports to be congested congested in order to extract payment
Okay, I think
from the providers.
we have your argument. Thank you.
Okay, thank you.
Mr. Russell, did you reserve 2 minutes?
Sure.
2
Let me
minutes.
maybe just make 2 points. One is in answer to Judge Williams' reference to the statement in Brand X. If you go back and look in the briefing in that case, the government offered the Supreme Court 2 reasons why visiting a third-party website involved an information service. One was because it involved DNS and caching. The second was the theory the Commission advances here, and the Supreme Court didn't mention it, didn't accept it. We mentioned that in our opening brief. It's an open question. In addition, because DNS and caching the court also in Brand X didn't consider whether DNS and caching fell within the telecommunications management exception. And so all of the bases that the government has given, that the FCC has given for its classification decision here were not decided in Brand X.
It is the case, is it not, that DNS and caching were not seen as coming under the telecommunications management exception before 2015.
I don't know that it wasn't addressed in
It
the
wasn't
cable
seen
modem
at all.
order.
Nobody saw it.
Well, nobody addressed it until then. In addition, with respect to the answer that you were given, Judge Millett, about why telephone service doesn't count as an information service, they gave reasons why telephone service is different from bias, but none of those reasons have any basis in the text of the statute. They said it's always used in conjunction and is principally used for budget. None of that has any bearing on the statutory question that they were compelled to ask. And then finally, with respect to 257, they've more or less acknowledged that the NPRM here did not reference, as it is required to do, Section 257 as a source of legal authority. It's a very simple thing. It's not too much to ask. All they've done instead is said, look, here's an explanation that nobody looking at the NPRM would know why they skipped over it. And it wasn't harmless because nobody grappled with the textual questions that we have dealt with here today about the meaning of the restrictive language in 257A because nobody thought it was on the table.
You don't dispute that it was clearly available, a transparency rule under 706?
Yes, had they invoked it. Had they not disavowed their authority under, have they not?
Yes, of course.
Yes, we agreed, Verizon held it as much. But we don't think that deprives us
So
of...
it seemed to me.
Excuse me?
So it seemed to me.
But it doesn't deprive us of standing because we are still objecting to the order as a whole. We're perfectly fine if
Yes,
you issue
but
an order.
it somewhat raises the question as to the indissoluble link between the transparency rule and every other aspect of the Commission's decision.
That's right. I think that's fair that our argument here depends on our claim, which I don't think the Commission can reject, that all of its decisions, its classification decision, its 706 decision, its disavowal
Well, why
of
its
any...
classification decision if it's agreed that 706 was available? Now, it's true that 706 might involve more powers than it thought was healthy for the industry and the users, but that doesn't mean it wouldn't have been a perfectly reasonable thing if the Commission had been told that 257 was not available.
Yes, my point is only that. We've made the case that the availability of the disclosure rule was important, both to their disavowal of authority under 706 and their disavowal of authority under Title II. And if you say that they didn't have authority to issue that disclosure rule, the whole thing has to come down and they have to go back and they have to decide whether they want to change their interpretation.
Why does the whole thing have to come down if the whole thing can be recreated perfectly easily under 706?
Because it's up to the Commission to decide whether they want to recreate it at all, whether they want to do it under
Talking
706.
about the plausibility that a block to Section 257 usage would lead to abandonment of the basic rule. And you, I don't think, offer a reason to believe that that's the case.
Well, I won't take up much more time. I don't think it's our burden. The FCC itself did not invoke its severability provision. It didn't argue that it is severable. And I think ultimately it's up to the Commission to decide how it wants to proceed, and not for this Court to guess how it would proceed.
Ms. Goldstein?
Sorry for the delay, Your Honor. So I think that what we heard about public safety from our friends on the other side really only drives home the failures here. The burden is not on us and has never been to show that someone has already died because of these issues. The burden is on us to submit a comment, and then the burden is on the FCC to actually consider public safety, which it didn't do here. Now,
They say that you use your own special, you buy your service under these special programs or special lines of service. Is that accurate?
So with respect to the question about enterprise services, some of the services that local government entities procure might be classified as enterprise services, but that doesn't actually solve the problem at all, because a lot of what we're talking about is our communications with individuals who buy mass market plans, who are either giving us information in emergency or getting information from us in an emergency using what are undoubtedly mass market plans. But I think that
Be an example of that.
So I'll give you again the example of the vaccine, the Public Health Services website, right? We use in some cases, we use mass market plans, but the person who's getting the information about where to get that vaccine, that person is probably not using a mass market plan. Oh, sorry, that person is probably not using an enterprise plan. That person is probably using a mass market plan. And so it's that slowing that is part of the issue here. But I think this just gets to the broader point, which is, these questions about how paid prioritization is going to have an impact here, what the plan types are, these are all issues for the commission, right? And the commission didn't even mention them, much less make any findings about them. Council may think that our harms are speculative, but it's for the agency to make a determination in the first instance. And the agency here didn't even mention them. That's its duty. That failure is fatal to this order.
Thank you.
Thank you.
Mr. Wu, you get to close us down.
I'll be very brief. First of all, the Commission identifies its authority to preempt here from its authority to reclassify and what it calls the necessary consequences of that reclassification. But the problem with that assertion of authority comes when you look at what the nature of those necessary consequences are. And here, that necessary consequence is the Commission's finding that it lacks statutory authority to regulate blocking and throttling and other practices. And what is unprecedented here, even going back to all the preemption authority cited by the Commission, is that it has not before cited an absence of authority in an area, a preclusion actually from doing anything, as a further basis for preventing states from acting. That's simply inconsistent with the idea that the Commission has to preempt state law in order to conduct its own authorized powers. The second thing the Commission argues, though, is that the act of reclassification by itself carries with it immunity from common carriage regulations, by which I think it means all common carriage regulations imposed by any sovereign. And the two problems with that is, first, that the order by its terms goes well beyond common carriage requirements. It uses common carriage requirements as an example, among other things, as a quotation of the types of state laws that would be preempted. But more fundamentally, even the statutory basis for common carriage regulations is questionable. The source cited in the Commission's briefs and in the order is Section 15351, which this court held in Verizon prohibited the Commission from imposing common carriage requirements on information services. But what the statute says is that it prohibits the imposition of common carriage under this chapter, which is the terms of the Communications Act. It does not say anything about state laws or local laws, and it certainly doesn't say anything about non-common carriage requirements, which this order attempts to preempt. And then my very final point is the argument that the Congress set this sort of division between federal and state authority, which the Commission identifies in Section 2, the jurisdictional provision of the statute. And first of all, a separate provision of the Communications Act, 601C1, expressly says that there is no implied effect on state laws. No state laws will be superseded unless expressly provided for. And whatever else Section 2 does, it does not explicitly refer to state laws. It talks only about the Commission's jurisdiction. Now, there is a preemption line. We're not debating that. There is a preemption line that comes from the case law and from the Commission's jurisdiction. But what I would say most clearly is that Section 2's division between interstate and intrastate, whatever consequence that have, is not the line between federal and state powers, and certainly is not intended to constrain state powers in this area. Where that line exists is most appropriately raised in individualized proceedings arising out of individual state laws, not in this pre-enforcement declaration of preemption.
All right, thank you very much. We're grateful to all the attorneys for their time, their excellent advocacy. It's been very helpful as we consider the case, and it is now submitted. Thank you.
Stand, please. This honorable court now stands adjourned until Monday morning at 9:30 a.m.